May it please, Your Lord.
Yes.
I seek apology, my lord, for 14. My lord, I was on legs in
No
another
problem,
court.
Mr. Yeah, you please make a mention.
Yes,
What is it?
My lord, so far item number 75 is concerned. It's been a part-hard matter, my lord, and 2013 matter. If your lordship allows me, and with the consent of the other side, may I upgrade it
We'll have it at 2 p.m.
at 2? Deeply obliged, sir.
Lordship, item number 67, 68, and 69. Lordship, in one case, I have already filed my affidavit. Remaining two, Lordship, I am filing today.
Have you taken the consent of the other side?
Lordship, other side has been informed, Lordship.
On the prayer of Mr. P. Naik, learned counsel appearing for the
BTC.
BTC authorities. The matter stands adjourned today to be listed again on 11/9/2024. So in the meanwhile, the respondents are at liberty to bring on record their stand by way of filing affidavits in the matters wherein such affidavits have not been.
Well, I'm for a petitioner in this case.
Petition, sir.
Well, interim order passed earlier shall continue.
The interim orders passed earlier shall continue until further orders.
I may be permitted to.
You're that college teacher that is ready. You will have it today or tomorrow it will be uploaded.
I'm paying for listing it, taking up a unlisted motion, my.
But that you'll have to go before the main bench. The main bench signing
It's
it.
not sitting today, my lord.
Huh? What is not sitting?
today, my lord.
What is the issue?
Well, this honorable court directed the authority to conduct the election on 18th. The term of the board of directors of the cooperative society is going to expire on 18th,
18th of this month.
18th of this month.
Hmm.
But they have not taken any initiative, my.
Okay.
Fine.
Get it. No
Lordship,
problem.
in item 64, Lordship, I am filing affidavit, Lordship, I am allowed to call for.
No. That matters.
May it please, your lordship, my lord, with the consent of the other side, my lord, I beg to mention item number 39, my lord. The my lord, respondent has filed the affidavit in opposition. I need to file my reply, my lord. 3 weeks time may be allowed, my lord.
On the prayer of Mr. H. Gupta, Mr. Dish, your name?
R.S. Mishra.
R.S. Mishra, learned counsel for the petitioner who submits that he be granted further 2 weeks' time to bring on record the rejoinder on behalf of the petitioner to the affidavit filed by the respondent. Prayer accepted. Registered to list this matters ahead on date 30, 3 weeks, Bishop.
Deeply obliged.
Lordship, recommendation for listing on admission matter. Next week, Lordship.
Yes, Mr.
But I beg to mention item number 15, Lord. But I have
50?
Yes, Lord.
That contempt. No, item number 15. 15 or 50?
15, man.
That bank matter. Okay, thing has been done. Your name has been deleted. So anything survives here. Item number 15, Decca Consultancy.
Yes, yes.
Anything survives.
No, Lord, the petitioner has got his relief.
Oh,
Lord.
that's it.
Lordship may close this petition.
Mr. R. Dubey, learned counsel for the petitioner
I am
submits,
for the bench.
submits that the
1, 2, 3, and 4.
the relief as sought for in the present proceedings, has been granted to the petitioner by the authorities during the pendency of the same. Also, Mr. M.K. Mishra, learned counsel appearing for the respondent number 1, 2, 3, and 4, does not dispute the above statement of above submission of Mr. Does not dispute the submission of Mr. R. Dubey, learned counsel for the petition. Accordingly, the petition stands dismissed as having become in progress. Yes, who is the gentleman standing? Yes.
Lordship, I have filed an IA and I am appearing in person, which is
Which matter?
listed at item number 74 in connection with item number 4 of the daily list. May kindly be heard along with the original case of item number 4 of the daily list.
Deepika Chamua? No.
Yes, my lord.
Huh?
I have filed an IA for impleading as a party, necessary party.
In this matter,
Yes, my
who are you?
Yes, I am the original complainant with the income tax department, and on the basis of this court's order, a FIR has been filed against me by the husband of the petitioner.
That you take up,
Lordship,
that
there are
take up
matters of suppression of facts. And
Mr. Counsel, we are not concerned here with any other issue other than whether a proceeding prior to the amendment of 2016 Act can be maintainable. If you
Lordship-
have any grievance, you come up before us with by way of, okay, we will have it when the matter is called up.
Thank you, my lord.
Have you informed the other side?
I have submitted already the copies of the IA has been submitted.
This is too much. Where were you for such a long time?
I am the informant and.
This matter is pending since 2020. Where were
I have
you?
written a number of letters, lordship, to
To-
Honorable Chief Justice.
That will not
No,
do.
my
You should
lord,
have.
they keep on watching the proceeding, having seen the trend of the.
We are
law.
passing orders today finally.
Yes.
No
And
problem,
what is the
lordship.
locus standi, my lord?
We'll take it. Yes, come, Mr. Chaudhary. Leave
What
it
is
to
this
us.
locus standi?
Leave it to me, Mr.
Yes, yes,
Chaudhary. I'll
yes.
handle it. Let the matter be called up. You be here.
Thank you, my lord.
Yes.
Lordship, I beg to mention item number 14 of this list.
Hmm.
In this matter, Lordship, Senior Counsel I. Chaudhary is engaged
Hmm.
and unfortunately he is at Arunachal today. And the matter has come up today, that if your Lordship may fix on 19th.
My lord,
on
my
the-
lord, humble prayer, my lord, let the matter may be reached, my lord, it's a tender matter, my lord.
Okay, you are not for the petitioner.
For the
My
respondent.
lord,
Lordship.
actually, in this matter, I'm appearing for the petitioner.
We'll hear you.
Yes.
We'll hear.
Let the
We'll-
matter
we'll
be-
just-
I told him not to mention the matter.
We'll check up.
There's a practice in this court. When the other side don't agree, mention is not made.
We'll check up.
Make please, your lordship. Lordship, I beg to mention item number 54, lordship.
Morning, it seems to be very hot today. Yes.
No, my lord, there is a practice in this
I know,
court.
you
When
know.
Other side don't agree.
In my court, I'll not permit it, Mr. Chaudhary. Don't worry. Yes.
Make please, your lordship. Lordship, I beg to mention item number 54, lordship. I have informed the government side. We need 1 week time to file affidavit, lordship.
You are for
For the petitioner, lordship.
what affidavit?
Affidavit in regards to the implementation of a small scale project on the petitioner's property, lordship. 1 week time may be granted.
This matter we had considered on the last occasion.
12th of
You want it in your property,
your lordship.
whereas they have done it in some other property.
Lordship.
We'll consider it when it reaches.
Lordship, 1 week time may be.
No. We had given you time on the last occasion. No further time. Where is Mr. Bonik?
He has informed me that he needs to, actually the petition is from Nagaon, so he was unable to turn up during last week, lordship. So 1 week time may be granted.
What right do you have, Mr. Counsel? What right do you have here? That's what I wanted Mr. Bonik to address me on. That this is my right, that this should be in my house only, in my property only.
Only one. Time.
Okay, be here when the matter is called up. We will consider your prayer. Don't worry.
Obliged.
May I please, your lordship, with the consent of the other side, madam, I beg to mention item number 33 to 35, madam. This matter is actually wrongly listed. It was fixed from 23rd of September, madam. I have the order. And the interim order is also appearing there.
Miss N. Gogoi, learned counsel appearing for the petition, submits that the matters have been wrongly listed in as much as this court had already required the matters to be listed on 23/9/2024. Twenty-three nine 2024. So, while order dated 2/8/2024 passed in WPC number 3038/2024. Also passed in an analogous matter being WPC number 3038/2024. Also registry accordingly is directed to list these matters along with WPC number 3038/2024 on 23/9/2024. Also interim orders are there?
Yes, madam.
Interim orders passed earlier to continue till the next date of mistake.
I do.
May I please, your lordship, I got to mention for listing pending matter.
Mr. Sharma, you will have the order by 19th or 20th. We'll dispose it of today. Disposed. 224. 23. আৰু এটা আছে লগত কিবা connected matter এটা থাকা আছে। কিমান আছে?
But in this case, an IA has been filed
Huh.
by the petitioner applicant in person seeking impleadment.
Hmm.
But this is not a criminal proceeding. where the complainant or the information has a right of audience in certain situation. That to my lord, even in a criminal case, when the informant comes, he cannot take an independent position, my lord. All that he can do is he can assess the PT. Now, in this proceeding, my lord, we have gone through the IA, he has not brought out anything, any fact which should, my lord, mitigate the case.
No, Mr. Chaudhary,
Yes.
so far as I remember your argument and my reading of the judgment of the Supreme Court 2023. Supreme Court in that case went into the question whether the Act of 88 was constitutionally valid.
Yes.
Then it came to a conclusion that Section 3 and Section 5, without any further provisions being made, was not proper, could not have been implemented. And it has also recorded the stand of the government that we had not implemented it in a criminal proceeding, but we had taken it to be a civil proceeding.
Yes.
Thereafter, the court went and examined the 2016 Act.
Yes.
On examination of the 2016 Act, so correct me if I'm wrong,
No, absolutely.
it came to a conclusion that these are new provisions brought in. So this is not a clarification of a substantial, it had to be they said it's a procedural law. Supreme Court went and said that no, it's both substantive as well as procedural law, and this cannot have a retroactive effect.
Yes.
It will have a prospective. Then it went to examine Article 20 bracketed 1,
Yes.
saying that this
On the
earlier
day,
thing, this will not come in because that was a civil nature. There was no penal consequences attached. So the court said very categorical, any proceeding initiated for transactions till from
Prior to that act.
88 to 16 will not be there. So your materials subject to the correction were from 2011 to 2014. So if that be so, the final conclusion, 127 or 128, final conclusion, those proceedings gone, cannot be touched. It will not be covered by the affidavit. They say that it's a procedural thing which we have brought in. Substantial law was already there. That aspect Supreme Court has said wrong.
already dealt with.
Dealt with. So now, in that view of the matter, whether somebody has filed an FIR, whether somebody has done something, as an officer of the court, I want you to assist me on that, whether that would have any bearing on the matter.
But it, from the perspective
Qua
of
the applicant.
applicant.
I'll hear him. Mr.
Yeah,
You have a
thank-
seat.
thank you.
You have your seat. I'll hear you.
In that case, may I pray, my lord? Let us also file an affidavit to their objection to their IA, and lots will hear us on that.
Gone down the drain.
So, my lord, since
I
they
know.
have come up with this some certain factual
Because see,
foundation.
if there is
I think
something we want to, I'll try to obliterate that also.
Yes,
Otherwise, prima facie, nothing is there.
yes.
Give me 2 minutes. Yes, Mr.
Lordship,
Bucha, what is your grievance?
this honorable court has passed an interim order
Hmm.
on 25/2020.
Hmm.
State Annexure 3,
Hmm.
Annexure 4 series,
Hmm.
and Annexure 7.
Hmm.
Dr. Durlabh Samoa, who is the husband of the writ petitioner,
Hmm.
is beneficiary in Annexure 3 and 7,
Hmm.
whereas copied in Annexure 4 series.
Hmm.
He is not a party in this suit.
Hmm.
Dr.
Who are
Durlabh,
you? Who are you?
I am coming up, Lordship.
No, first you tell me who you
I
are.
am the person who filed the application as per the scheme launched by the government of India, Benami Transaction Informant Reward Scheme
Where is
2018
where is your?
at Annexure 1, page number 19.
Hmm.
On 29th October 2018, I have submitted the information along with Mr. Hemanta Devdi.
Hmm.
Along with this application, I have submitted.
Now tell me one thing, Mr. Mr. Bucha.
Lordship.
Am I right in your name? Mr. Vikas Bucha, right?
Yes, my lord.
The properties that are involved, which you say are Benami of Dr. Durlabh Chamua, not of Deepika Chamua. These properties were transacted. Transactions in these properties had occasion prior to 2016 or after 2016.
Lordship, I have clearly mentioned at point number F,
Hmm.
the date on which the payments
So
were made.
any date here after 2016?
Lordship, I have a detailed submission because the merits of the writ petition is defective.
Have you seen the latest judgment of the Supreme Court?
Lordship, I have seen it.
Then-
Lordship, I have seen it.
Explain it on
I
that.
have not read it down, but it has been appraised to me that the honor has been set aside.
So it's the Supreme Court says that any transaction prior to two thousand
After two
sixteen.
thousand sixteen matters will be entertained by the
So
income tax department.
what can I do for you here?
Let me complete, Lordship.
Mm.
I have submitted 4 documents along with my application. At page number 22 may kindly be seen. Sale agreement number 9629/11. Sale deed number 9625/11. Affidavit in form 26 dated 23/3/2011 and affidavit form 26 dated 19/3/2016. All these 4 documents needs to be mentioned in the writ petition because the relief has not given by the
I'm not on that,
Lord-
Mr. Butcher.
Lordship. I'm submitting, Lordship.
No, you
the sale-
clarify, you clarify on this point whether in light of the Supreme Court judgment,
Lordship.
I can entertain the issue that the proceedings and
Lordship,
whether the
tomorrow-
proceedings against the petitioner is
Lordship,
maintainable.
Definitely, Honorable Supreme Court passed an order. That order can also be challenged.
You go challenge it.
Yes, definitely. To challenge that order, I need to be implicated in this case
No.
because secondly, Lordship, let me complete, Lordship. This order of this honorable court was utilized as an annexure document in the FIR without informing this court. Lordship, please.
Have you filed any proceedings against that institution of that FIR?
Lordship, recently this FIR has come to my knowledge. That's why I'm coming to this court first to inform this about the incidents, and if required, I will take appropriate actions
You
accordingly.
please do so. Whatever
Lord-
is
Lord-
permissible,
Lord-
do so. Come before us with
Lord-
that. We will entertain.
Lordship-
We'll consider.
Lordship, what is my submission
Okay,
is,
tell me, what do you do?
yes, sir,
What is your vocation? What do you do
I am a
as,
businessman, Lordship,
where posted here?
here in Guwahati, Lordship.
Okay.
See page
What is
number,
the source of your knowledge?
Lordship,
That page 20.
the
you-
FIR itself will
No.
explain,
This page 19 you have submitted.
yes,
What is the source of the knowledge?
the page number 71 is the source, Lordship, that husband of the writ petitioner himself submitted before the police, that I am the person who
Not of
has,
that. I am on page 19. You had initiated the proceedings.
yes, Lordship.
So what was the source of this information to you?
Lordship, I was a former employee of a company named Protect Realtors Private Limited.
Hmm.
And this is confirmed by the husband of the writ petitioner as well at page number 71, you may see it. And I will just read down the paragraph.
I don't want you explain your status.
What
Because
is been written, it is in
Mr.
2019.
Counsel, your complaint,
My submission is,
Mr.
Lordship.
Butcher, your complaint was acted upon by the income tax authorities.
yes, Lordship,
Proceedings were initiated.
Lordship,
So your complaint, whatever it was, has been acted upon.
yes, Lordship.
What more are you doing?
I have no grievance with the income tax department except,
Enough.
Lordship, please complete, let me complete.
Your grievance has been taken up.
No.
If you are against,
Lordship,
I'll
because-
pass an order here. If you are,
On the basis of the orders of this court, FIRs has been,
please,
let me
Mr. Counsel,
complete,
Mr.
Lordship.
Butcher, you
Let-
bring on record a proceeding on that lines.
let me complete, Lordship. There is a forged document filed in the writ petition. And this is under the custody of the police. This fact has not been submitted in this court.
Fine, I'm only with the proceedings only. I'm not with anything else.
Absolutely, Lordship. That's why just record my objection in regards to the submission of forged document in a court which is in the police custody. Police is
What is that document? Show me.
annexure number 2. Lordship, I have written 2 letters to the Honorable Chief Justice Guwahati High Court.
Annexure number?
The letter number, annexure 11A, page number 60.
Yes.
In this letter, I have requested Honorable Court for conducting the hearing that has been done, Lordship, and verification of the genuineness of annexure 2 will of Pratima Chamma, which is submitted along with the writ petition.
What is your objection with regard to this?
Page number 34, Lordship, is the statement of the investigating officers who seized the document.
Where is that?
Page number 34, Lordship.
Of the affidavit or your IA?
Aye, Lordship. Statement of SI Privat Gogoi, age 32, presently Ayo Pan Bazaar, PS case number 368 oblique
Okay, in
2020.
connection of the earlier statement taken so and so, a prayer submitted before providing sale permission original in connection with the case for export examination. So and so case is pending for a FSL examination of seized document after seize. Now, what is the problem with this document?
This document has not been acted upon. The investigation has not been done due to non-cooperation of non-cooperation of the income tax department, which is the respondent number 2.
Mr. You have made a submission that page 16 is a forged document,
Lordship,
right?
Lordship.
It's a will, it's a forged document.
Yes.
Take up appropriate steps.
It is already under the
That will be taken to its logical conclusion by the.
Lordship, this petition has been decided on merit. When
We
a
are not, we are on a
document
technical,
question is-
we are only deciding this merit, this question on a technicality. That's
Lordship,
all.
on 21st December 2021 order, they decided in the order, it is to be
When
decided on
did you
merits.
know, when did you know about the pendency of this proceedings? First knowledge of this pendency of this proceedings.
Pendency of the proceedings has been come around in 2021, Lordship.
Then why did you not come up immediately thereafter? Why today?
Lordship, till the time, nobody, I have no documental evidence that any criminal.
You said you have been writing letters to the Chief Justice.
Yes,
When was the
Lordship.
first letter written?
On 24th of August
Of
23.
23.
Yes, Lordship.
Then what was the plea taken there?
Then after
What was the plea taken there?
Lordship,
What was your plea there?
there is only verification of the genuineness of the annexure 2. Because
Annexure
it is
2.
submitted in
That
the
is before
petition.
that is before the police? That is seized by the police?
Yes, Lordship.
Police, according to you, have not taken the matter to its logical conclusion.
We have already gone to the CGM
Hmm.
where it has been found that Lordship, that statement has already been there in the at
Not
page-
satisfied with regard to your
Lordship,
impleading
this is
application.
matter of a forged document, and on the basis of forged document, they are getting the interim orders, and on the basis of interim orders, they are filing criminal case. And the corruption matter is pending in this court, Lordship, where I am the applicant in person, and the Dr. Dullab Samoa is the respondent represented by the
Dulab
senior
Samoa
counsel.
is not
And
here.
another proceeding has been pending in this court, Lordship. Another proceedings has been pending in this court.
What is that?
On the
What is that?
Lordship, the order has been annexed at page number 89. The order dated 19/6/2024 was there. Lordship, the state authorities are totally in hand in glove. In 2021, they are seeking permission from the government for registration of criminal case in the PC Act for disproportionate asset amounting rupees 2 crore 16
Very good.
lakhs.
This is a very good
After
proceeding.
that, FIR has been filed
Mr. Bachua,
against me, Lordship.
Mr. Bachua,
And
this-
after 3 years, government has been submitting.
Oh, this is a very appropriate proceeding you have initiated. Before this court, page 90 order. If there is an allegation of the disproportionate asset against something, you are a whistleblower, you have come before this court, we will take it to the
The
logical.
same person using this matters order as a document claiming the falsehood of my proceedings, Lordship. Because in this writ petition, nowhere my name is mentioned. No.
How many,
annexure
how
my
many,
name is
how
there.
many, how many such proceedings have you initiated? Against how many people have you made such allegations?
Lordship, at least 3 numbers of persons are there. In
No,
one
no, no, no.
MLA, former MLA case has already been registered.
Against this, in sort of this, in addition to the proceedings against Durlab Samoa and his family, against how many other people? You
3
seem to,
numbers of other persons has been there.
who are they?
One Mr. Anamul Haq is there.
Hmm.
Already FIR has been registered.
No.
2 proceedings are there in the very initial stage where I have not implemented because the nature of criminal cases registered by the police on the basis of the complaints filed by the Dr. Durlab Samoa and families. 11 or 12 FIRs has been registered.
Against you?
Yes, Lordship. After I have informed.
Have you taken bail in those matters?
Sir, in one matter, the Bureau of Investigation Economic Offense, I have enclosed at page number this, rather the sigil list of the title documents of this.
Okay,
This
we've
case
got
has
it.
been there.
We have got it. Mr.
But
Sorry.
I wanted to file an affidavit just to show who Mr. Bucha is.
I know, I want that.
What is his connection with the?
I want that now,
Ah.
because
Yes,
apparently something is there.
yes.
And with
That's
regard
why
to
I
the,
need to file an
with
affidavit.
regard to the proceedings, he has initiated in page 90.
Yes.
That is an independent proceeding.
Well, in that
That will
case,
go on.
in that case, state has declined to grant any permission.
Need not be, because you are no longer, the Mr. Somua may no longer be the public servant, so sanction may not be required. But that, whether that can be connected to these proceedings, that's the
Cannot
issue.
be. That's right. That is his perception that it is connected.
Okay. Petitioner in person is before us. We will give him the
Yes.
that
yes.
much liberty.
No, that's why I wanted to
You,
file an affidavit to show. who will react to this.
Also, this matter, WPC लिखी these matters तीनटा एकलगे लिखी बात were fixed today for delivery of orders. However, an impleading application being interlocutory the IAC number 2433/2024 has been instituted by one Mr. Bikas Bucha, who contends to be the complainant who contends to be the person lodging the complaint, who contends to be the informant lodging the complaint with regard to the Benami transactions forming part of the allegations leveled against the petitioner in WPC number 2184 of 2020. Also, Mr. Bucha submits that he, being a interested person in the proceedings of WPC number 2184/2020, being the informant therein, is required to be impleaded as a party respondent. Also, Mr. K.N. Chaudhary, Learned Counsel, Senior Counsel representing
My
the
submission
petition.
is neither a proper party nor a necessary.
Mr. K.N. Chaudhary, Learned Senior Counsel appearing for the petitioner, submits that a mere perusal of the contentions brought on record and the issue raised in WPC number 2184/2024 would reveal that the applicant in IC number 2433/2024 is not a necessary and or proper party into the proceedings. Be that as it may, Mr. Chaudhary submits that he be granted 2 weeks' time to bring on record the objections on behalf of the petitioner in WPC number 2184 of 2024. Also, prayer accepted. IAC2 he tate khumai diba de ekelage tinta logot IAC2 khumai diba. List this matters again. But Mr. Chaudhary, I'll not be here.
Whenever it was sitting next.
I'll have it on 9th, if not inconvenient. Mr. Bucha, on 9/9/2024 for admission split.
On the IMB, right?
No, we'll have on that day, we'll finish it. If we implead him, we'll hear him.
Okay.
Right? If we find that he is not to be impleaded, we'll reject his application and proceed.
And the other point which your lordship has put, that also I'll answer regarding today's context.
Huh.
Regarding the judgment.
Judgment.
Obliged, my lord.
I may plead for the income tax department.
Mr. S.C.K. Learned Counsel appears for the income tax department. Upot kubarta likhito ba? Mr. I applicant appears in person.
And for responding.
Mr. Bucha, it's on 9th. 9/9. But you be also very that all these things may not satisfy us. You also be ready with that Supreme Court judgment.
Lordship.
Peruse that.
Lordship.
Because we are only concerned with that in this.
Oh, lordship.
CAV quickly. I'm sorry, I'll not be here from 19th. I'm making it CAV. We'll deliver the order in the meantime.
But only I wanted to point out, my lord, that we had given a chart that on during his tenure only that there was.
I have seen that. I've seen that. Okay.
Apart from other laws, my lord. Obliged, my lord.
May your lordship. I would like to give
Amen.
some secular.
File to be done for my today.
Obliged, my lord.
Or we'll do it like this. We'll fix it on 5th. We'll deliver the order on that.
Fifth.
The delivery of the order is referred today and the matter to be listed on 5/9/2024 for delivery of orders. 5/9/20.
My lord, can it be on 6th, my lord?
No, you need not be here. You'll only deliver the order.
Obliged.
Mr. Chaudhary, we have gone through it. We have formulated also, but unfortunately, yesterday something happened. I could not dictate.
No, only thing, my lord, the state, they argued on paragraph 12 of Ajay Chaudhary. If your lordship should kindly read para 3 of Ajay Chaudhary, that is in the factual. What had happened, my lord? Just kindly permit me. In this case, the last extension was given on 22/3/13 in Ajay Chaudhary. In the meantime, he went to CAT, my lord. CAT said that if by 21/6/13 it is not reviewed or no disciplinary proceeding is initiated, then the transfer order will lose its force. It is in that context, my lord, in para 22. Because state every time says, after giving relief in 21, how come in 22? This observation.
That was also my,
3.
that was also my view, but
Yes.
unfortunately, I never examined it.
Yes.
Only examined it the other day when it was being done.
Yes.
And we will also, our tenor of the order would be that we will accept Mr. 3 submissions. One, he has brought in some judgments wherein he says that once the order is issued, then the show cause is issued, there is no time frame given.
No, there is.
Immediate.
That is there.
Along with the. So he relies on Prasanto Dutta, wherein you have appeared, because is my Lord Justice Borua's order.
Yes.
Therein, Justice Borua had segregated the 3 sentences into 2 parts. One, he says 90 days. And the second part, he says it should be along with it. Should be along with it, there is no clarification. They say there is a ambiguity that we will fill up to that extent. And then he says reasons. I had an occasion to go through the file. Mr. Nayak will not, I maybe today submit much on that. That day he did not look into the file. That's why he was
I
making.
didn't get the opportunity.
That today I'm sure he will not make submissions.
Having gone to
Because
file-
the only thing reason that is there that I find is that because the criminal proceeding is pending, so the order has to be reviewed. That's the sum and substance. And there are many other material which I would not like to disclose.
No, my submission was at the time or immediately.
That we will clarify. Following,
Second.
following my Lord Justice Borua's judgment, we'll clarify. I'm ready.
That too only, at that time or immediately. And second lordship, once the search memo is served.
Yesterday,
Then 21
yesterday he was
becomes
there.
done.
I dictated 2 matters. This was the third I was to take up.
Okay.
There was a big blast in my house. The transformer went off, 2,
Oh.
3 lights. Then the whole evening went with that only.
Just one more information, lordship. Last extension was issued on 27/6.
We'll not go to the subsequent one. We will examine the requirement whether with the show cause notice, an extension or a reason has to be assigned. If we hold that that is to be assigned, not assigned, subsequent things become OTS. And we are not, Mr. Chaudhary, we are not going into the question whether the suspension order was right or not. We are only examining the question whether the prolonged suspension is correct or not.
In fact,
Reinstated.
perhaps that could be another facet which can be added to this matter. Something like, my lord, long incarceration,
That
even, my lord, the rigors of UAP Act also Supreme Court has not.
what I am on is I'm not going into the question whether the suspension order was valid or not.
Yes.
That I cannot go into because
Whether
that is
prolonged suspension
prolonged
affects
suspension.
the right of the delinquent.
And I'll give you the liberty under para 21 law later part, wherein it says you can even post him to the Assam House in Delhi, no problem.
Yes.
No, that division bench also given me the liberty to suspend him again.
Having regard.
Please
to
do
the-
so.
Having regard to the contours now, I think lordships can extend to that. That prolonged suspension, if it affects, then what would be the consequence?
Prolonged
Because
suspension,
nowadays lordship has seen even now, recently
PMLA.
Supreme Court orders on bail. Now, section 37 bar does not apply in case of long incarceration.
Mr. Chaudhary, with a caveat that even if this is to be extended, it can be extended only with regard to the prescription in the first 3 lines of para 21.
Yes.
By exercising that, and I'll just follow my Lord Justice Borua's judgments, wherein he says, after 90 days, nothing. So the corollary would be, if after 90 days you don't have the power to even continue the suspension for 1 day in absence of a show cause notice, where will that power be if the show cause notice is issued
Even if
and
it is
a
issued.
addendum thereto in form of a reasoned order requiring the giving the reasons as why you should be your suspension should be extended, I would say it will not be met.
In my,
other words, whether the declaration in the first three line of 21, in that case, my lord, it will amount to diluting the very first three sentence.
No, I'll say 90 days is the limit.
Yes.
Beyond that, you cannot. And if you issue a show cause notice within that 90 days, if it is not accompanied either on the date of issue of the show cause or on the date of receipt by the incumbent, by the delinquent of the reasons as to whether the suspension is to be extended or not, the suspension order would come to an end. This is what I'm trying to do.
Tentatively, that is-
Tentatively, this is my I'm reserving it. I'll deliver it from Mizoram.
just one more point, Lordship. Justice D. Bora's judgment says, Ajay Chaudhary judgment gave you a right. You have to assert that right after completion of the period of 90 days. If in the meantime, thereafter, search memo is issued, paragraph 22 comes into effect. That is, in my
Para
understanding, there
22,
was.
with all respect, I'll submit, my lord, that was in a different context. You can't read para 21 and 22. Para
21
para
is
22
the
is the principle
dicta.
of law.
I
and
placed
para
21
22
is the dicta.
observation in the
I'll
first
deal with
place.
I have filed one written submission.
I know it.
Thereafter, I filed two judgments.
I have with me.
I am
I've
relying
got it.
on those judgments also.
I'll go into it.
Nothing.
I think my learned friend has missed para 3 million of the Ajay Chaudhary, where it is clearly said, because
I've
in
got it,
terms of
so-
the CAS direction, in fact, so cause notice was issued. That's why it was said that in the facts of the case.
You will have it. I'll deliver it from
No.
Mizoram. That much liberty I'm taking. Dispose no to see we go. Yes, Mr. Chaudhary.
Lordship, on the last occasion,
Hmm.
Lordship has asked me for the whether that page 46, those two items which were excluded. Lordship, the office, since it's an old matter, they are searching, they have requested me just for a few more days. They will locate it because since the office has shifted from an old building to new building.
That set-top box and encoder.
Yes.
Yes, what do you have to say, Mr. Cheriya? Anything more?
Lord, I'd like to place one more judgment, my lord. It says, my lord, in taxing statute, my lord.
It has to be specific.
If two views are possible, my lord.
Then the view-
In favor of the SSC has to be taken into account.
But here, let us come to that conclusion that two views are possible.
Lordship.
For
In
that,
case-
for that, I'll have to finally hear him.
Lordship, otherwise also, my lord, if your lordship may see the entry, my lord, the products, my lord. On the last occasion, your lordship has
Aha.
raised a query, my lord,
Mm.
whether television can run without a program, and program is, my lord, coming up through telecast, my lord. My lord, in fact, my lord, if your lordship sees the other item, my lord, that is the, my lord, video cassette recorder, video cassette players, video cassette tapes, my lord, these item, my lord, these are not wireless, and in fact, these also, my lord, telecast, my lord, programs have been converted to the television, my lord. Therefore, my lord, the items, my lord, which is included in, my lord, entry 4, my lord, all these items are, my lord, the final products ultimately utilized by the, my lord, viewers or, my lord, the listeners, my lord. That is the.
You mean to say that the items given therein are inclusive items?
Lord,
If not specified,
Lord,
then that cannot be said to be an entry
my lord.
wherein a tax can be applied.
My lord, in fact, my lord, the general entry, my lord, and as I submitted on the last occasion, my lord, it takes color of the, my lord, other entries mentioned in the schedule, my lord. So these are the restricted items, my lord, these are the final items.
But
final
Mr. Chaudhary, the problem is I'm not here from 19th for 2 weeks.
Lordship, on the first day of Lordship availability, Lordship.
2, 3 I have fixed matters. We'll have it on 5th. Mr. Chetia, on 5th. Mr. B. Chaudhary, Learned Counsel, appearing for the state respondents. Standing Counsel, Taxation and Finance Department, appearing for the state finance, appearing for the respondents, submits that he be given 2 weeks time to bring on record the basis for issuance of the impugned order dated 2/4/2023, right?
Yes.
2/4/2023. Post of key contents that as the office had shifted in the meantime, the files are not being located. Also, however, he submits that on the next day of listing, he shall apprise this court and also make his submissions in the matter. Also, Mr. Chetia has been further heard today, and he has also placed on record further judgments. Also, in view of the above position and for the interest of justice, raised to list those matters again on 5/9/2024 as a top apostrophe malignant, as a top of the list item matter, as a top of the list apostrophe over matter for further hearing. Mr. What to do with this? Second day, it's a petitioner in person matter.
Yes, boss.
His phone numbers are given.
Probably. Ramu Lakshmi or this guy.
This one also. The none appears for the petitioner on call. It is seen that the petitioner is appearing in the matter in person. However, on the last date of listing also, no representation was so made on behalf of the petitioner. Also, registry to list this matters again on 21/8/2024. Also, the registry shall contact the petitioner on his mobile number given in the affidavit and convey to the petitioner the next date of listing in the matter. Also, it is provided that in the event there is no representation on the next date also, this court would contemplate passing appropriate orders as may be deemed fit and proper. Also, a note to the effect that the petitioner has been intimated about the next date of listing be put up on the next date by the registry. Yes, yes, madam, what happened?
Instructions are awaited, Your Lordship.
Wait. You have literally allowed by way of, you're not disputing this annexures, are you?
Lordship, these have been signed by the executive engineer, but as per Tamsher Ali, the admission has to come from the head of the department.
But your non-response will also be, have been giving you time. Okay, no.
Lordship, it
Miss
has been-
M. Kolita,
Lordship,
a learned counsel appearing for the
PHA department.
PHC department submits that the instructions in the matter have not been received by her till date. Accordingly, she prays that the matter be taken up on 2/9/2024, by which date she shall place on record the instructions in the matter. The learned counsel for the petitioner is present. Next
The
day,
next item is also same.
same, 11/12, same order.
Obliged, Your Lordship.
Well, item 12, Lordship, I want to withdraw, Lordship. On last week, Lordship, respondent authorities has called the petitioner that the fund has released.
Mr. A. Hussain, item number 12. Mr. A. Hussain, learned counsel for the petitioner submits that the petitioner desires not to press the matter any further. And accordingly, he prays that he be permitted to withdraw the petition. The prayer is not objected to by Ms. M. Kolita, standing counsel, PHC. So accordingly, the petition stands dismissed for non-prosecution. Who is appearing for the respondents here? No. This next matter, 1/4/30. Mr. Borwa,
Yes.
requisition matters, why keep it pending? You have your instructions.
Lordship has already disposed of my lord.
No, no,
similar- That is different, but ultimately we have to.
My order.
verify whether- Yes. Similar and identical nature, my lord, I will examine and they will verify and they will give money.
Okay. Mr. Borwa, we had disposed of similar matters wherein we have said that while you are not disputing the requisition, you are disputing the amount claimed.
Hmm.
So for that, an inquiry will be made, and in terms of that inquiry, if it is found that he is entitled, he will be paid. Not much only.
No, that is only thing.
We'll do that. We'll
Hmm.
dispose it of.
Yes.
J.I. Your vehicles have been released to you.
All the same, my lord, only the payments have not been.
It is by the Commissioner of Police.
My lord,
Respond number 6. Who has requisitioned your vehicles?
my lord, MTO, that is,
Under?
my lord, put respondent number 6, my lord.
District Magistrate Kamrup Medical.
And you
And
had
my
given-
vehicle was requisition lordship for a random check, my lord, page 20. Additional district magistrate Kamrup Metro.
Now it will be paid by whom?
It will be paid by the superintendent of police, my lord.
That is the Commissioner, no?
Yes, my lord. The commissioner of.
You had given a list somewhere of the
Yes, my
dates.
lord.
Where is that?
That your lordship will see at annexure. Annexure 2, my lord,
Page?
page 35.
We'll ask you to approach the Commissioner of Police.
My lord.
Commissioner of Police लिखा है, हाँ? मेरे ये कोड नंबर रेस्पॉन्ड नंबर 6 है ना, उसका अच्छा से ले लेना.
Phone number. No.
Item number.
30.
इसका अंदर रख दो तो. Dispose of.
Oblige, my lord.
Mr. Chaudhary, when is the last date for the submission of tenders?
20.
Huh?
20.
20th. And have you submitted your bids, or are you in a position to submit your bids?
We have submitted, but what I'm saying is, well, it's a very peculiar situation, my lord. Well, whether it can be construed as tender, that is also an issue.
The rates are fixed.
Not only rate, my lord, what will be assessed? Normally, my lord, the credentials of.
BS4.
Huh?
BS4.
Now
They
there's
have
a
written
concept
somewhere.
called quality cost based selection.
Hmm.
So, my lord, neither is to be as, is it a tender, my lord? Tata Cellular Supreme Court has said, what are the attributes of a tender? It does not qualify. So, my lord, what will be assessed? How a bidder will be given the work? Kindly see, my lord, it's a very peculiar.
I
tab.
tried to find out the yardsticks for evaluation. That's
Nothing.
what I don't find.
Now, if your lordships will kindly come to page number, I'm coming.
Or is it like this, Mr. Chaudhary,
Yes,
that the vehicles that would be brought in,
yes.
they want BS4 standard vehicles. So amongst the BS4 standard vehicles, whichever would come in,
Huh.
they will hold a lottery. Say 100 is there. Innova, they require say 10.
Huh.
So within that 10, they will hold a 10 Innovas, 100 Innovas put together, then a lottery.
No, what they will do, they will shortlist 500.
Huh.
Out of
500 how? Category wise or total?
though the number is given.
That you just clarify.
Yes.
Because I find it here at page 48.
Please come,
Sorry.
my lord, page number 47.
Hmm.
Draw of lots.
Hmm.
Against the current requirement of 372 vehicles under tender, a total of 500 applicants will be selected by the first round of draw of lot. The first 370 would be ranked as the shortlisted applicants, and the rest 370 to 500 sequentially ranked as waitlisted applicants category wise.
No, Mr. Page 46. If you come to page 46.
46 are the numbers.
No,
Category 1, Mahindra Bolero 278.
28.
Then MM
45.
28.
Now,
Then
this all together works out to 372.
370.
So against 372, they will shortlist 500.
500.
But is that shortlisting category wise or it is total?
Not very clear.
That's
Not
some-
clear. And secondly, my lord, how can they restrict it to the age of the applicant, my lord? Number one. And kindly see one very dangerous clause in this tender. Please come to page number 108, my lord. Now there are two categories. One is self-driven, other is owners. Page 108. Kindly see Mahindra and Mahindra Bolero. The driver has to do 24 hours duty, and he cannot engage any driver. He has to drive itself.
Where do you get it?
Page 108.
Okay, Embarable, you see make model as per duty hours 22, 24.
Page 108, my lord.
Yes, Mr. Counsel,
Second
what is
column.
about this 24-hour duty thing?
Yes. And kindly come to 109. Please come to 109. Kindly see light serial 13. Light vehicles have been classified into two categories. Self-driven owner. Light vehicles shall be driven by owner himself throughout the contract period. Owner has to be given written undertaking that if at any stage it is found that the vehicle is being driven by some other driver, the contract shall be terminated. That means I am supposed to drive for 24 hours because that category of vehicle they require for 24 hours. I can't even engage a driver. And my lord, they have restricted to the age of the owner in respect of either category of vehicle. At page 57.
No, that 24-hour duty has been clarified in page 110, page clause 15.
My lord,
110 clause 15.
clause, my lord.
15.
24
24-hour duty.
means the duty paid for and calling for the presence of driver, including his driver, in ready condition round carry out. No, my lord, he should be ready to drive the vehicle 24 hours.
That means you must be round the clock, you must be
Yes,
waiting
my lord.
for a
No,
call.
all that I am saying is you must test either the eligibility or the price criteria. Nothing is there, my lord.
So the last date according to you is
Is it
20th.
zero? My lord,
And
my
you have
claim
submitted.
is- My lord, let tender process go on. They will not finalize.
No, we'll have it on 20th itself. Let
Okay,
Mr.
19.
Let it
Nine-
be 19. my lord.
19th itself. You get your thing. We are not passing any interim orders today.
Lordship,
We'll hear the matter on 19th.
Lordship,
But
Lordship.
on 19th, if you don't
Lordship.
argue,
19.
then these points will have to be given a consideration.
Lordship.
As Mr. Your name?
MK Das, Lordship.
MK Das, Lanak, Mr. K. N. Chaudhary, Lanak Council appearing for the for the petitioner, assisted by heard Mr. K. N. Chaudhary, Lanak Senior Counsel, assisted by Mr. L. N. Dinya, appearing for the Lanak Council, appearing for the petitioner. Also heard Mr.
MK Das Lordship.
M.K. Das, Learned Counsel, representing the Oil ONGC Limited,
Respondent
Mr.
1 to 9 Lordship.
ONGC Limited. Mr. Das submits that the arguing counsel, Mr. I. Chaudhary, Learned Senior Arguing Counsel, Mr. I. Chaudhary, for certain pre-engagements is not in a position to be present in the court today and accordingly prays that the matter be taken up on 19th. A perusal of the NIT involved questioned in the present proceeding shows that the last date for submission of bids is 20th. Accordingly, 28/2024. Accordingly, the writ petition is directed to be listed for consideration of the matter as well as the interim prayer made on 19/8/2024. The respondents shall also receive instructions with regard to the contentions of the petitioners raised in the present proceedings and place the same before this court on the next date of the
Lordship.
hearing.
Come in motion.
Motion,
Yeah.
four
Deeply
motions.
obliged.
Deeply.
List again on 19/8/2024, four motions. इसको type करके दे दो. ये तो पठाई दिया है क्या? Yes, Mr. Chaudhary.
What do you also kindly see they're deciding on which date market is to be conducted? On the basis of letter of the MLA. The also kindly see page 76. Several times, it is, I think, 10 outdoor litigation, I think, on the, almost on the same point. Several times it came out, and it was clarified that the deck cannot decide on which day market is to be conducted.
You are referring to some directions of this court. Where is that? Earlier directions?
Earlier page 29. 29 to 36. Your lordship will find it page 35. That. Thirty-five made a second middle portion.
No, I've got it. It should be operated on Fridays.
Friday.
Of any days operated on Tuesday instead of Friday.
Yes. MLA has written, because it's clash with their party might of them, how they can decide. It is a private market on the private land since December 2013, this market is continuing. On the same,
Now, what is the impugned here?
yes. Page 76, your lordship will find. Your lordship, first line, that one shows a MLA writing a letter for passing necessary order to stop the.
On receipt of so and so for passing necessary
Thereafter
orders.
inquiry was made. Inquiry is what
Stop
is your
so and so,
lordship.
so and so, so and so, so and so, so and so, so. The records of both Basumara Pasuhat and Basumara University nearly Pasumara by found.
They are giving more revenue, this is the. In term of need that we got also permit, no objection also given to us.
Yes, Mr.
That is
Counsel.
on record.
Headache. What do you say?
To evaluate the entire litigation over here, Miller, one has to peruse section 107 of the Panchayat Act. Miller. To operate or to start a private market
No,
on
Mr.
your piece of land, you need to take two permissions, two approvals, one from the Panchayat authorities and one
No,
from the
forget
government.
it, forget it. We will have it. But what is the basis for passing this order, speaking order? does not seem to be some provision of law. It seems to be emanating, maybe it's correct, he can always make a complaint. But it seems to emanate from a letter from a elected authority. But after that, how the mind was applied, what were the factors taken into consideration, we don't find anything. Because there are orders of this court passed earlier,
Yes.
whether that has been given a meaning.
Well, that
So
question-
today is Friday. That thing is gone. He cannot operate the market today. So what we do is we fix this matter on Wednesday. You complete your instructions on that point, the basis.
Well, this answer can be better answered by the DC, Malak, because he has passed this impugned order.
No,
Ask the
but-
PNRD department.
Okay. DC has passed. Okay, we'll have the DC.
Gotcha.
Okay. You, Mr. Roy,
Gotcha.
you get the basis for this decision?
Gotcha.
Qua the earlier litigation,
Gotcha.
wherein this court had given specific directions. So you get that, place it Tuesday or Wednesday?
Wednesday.
Wednesday, because Friday would be the next day.
Yes.
So you operate whenever they are permitted for the time being.
Yes. Today is the
On
Friday.
Wednesday, we will see if that is possible. We'll have it on Friday for you.
However,
Right.
Malak, there's one aspect that I would like to bring to your kind notice. The very locus of the petitioner is questionable, Malak, because he's operating this market without taking the prior approval of the concerned authority.
But
of
that
the
is not,
competent
but
authority.
that is not
That
reflected.
is not reflecting in
Then-
this order,
But
but
then,
that is the stand of the PNRD department.
fine, but we are only concerned with this impugned order today. And that is not a matter germane from or emanating from those pages, two
Malak,
pages.
It is actually at page 77, the second paragraph. But he's not reflected it in his order. It says, further, the Guwahati High Court in its.
I got it. That's
Yeah.
why I'm saying the Gaudi High Court says
That-
it's a
that is
private
what
land.
is-
Subject
Huh?
to the requirement.
It is there, we got it, man.
You got the
Yeah,
permission.
license is there, man.
It's not annexed
Yeah,
here.
page-
this-
Yeah, page 42, my lord, it is there, my lord. Page 42. And it is your lordship, it is mentioned in the page 76 also, my lord. Page 76,
42. Just a one, 42.
yes.
Is the DCs. It's not the
Page 42,
PNRD
man.
secretaries.
Here the day for operation is not given.
That now, they stopped the market, my lord. That is the-
Okay. Then
because
you
the-
came up here.
Now you will kindly say page 76, last part one paragraph.
70.
Page 76, in three order, last part one.
It is
paragraph.
also so and so collected huge amount of government revenue from the June
Records,
last year.
last part one paragraph, and circle of the report.
Huh.
That the records of both so and so market was called verified. It is seen that the papers and NOCs are found similar.
Ah.
But they are regularly depositing the government revenue, etc.
Naturally, you are there, you will be only depositing some fee.
That is, that we are paying, my
Ah.
lord. Page 64 onward, my lord. Several year we have given, my lord. Page 75.
Okay.
But if my lord peruses
45.
section 107, things will become.
No, you have your material on Wednesday,
Wednesday.
but you get your basis. The petitioners in the heard Mr. H.R.H. Chaudhary, Learned Counsel, Senior Counsel, assisted by Mr. R. Mullah, Learned AFN Mullah. Rose, the name comes first. What to do? AFN Mullah, Learned Counsel, appearing for the petitioner. Also heard Mr. S.S. Roy, Learned Counsel, appearing for the government advocate, appearing for the heard Mr. P. Hendick, Learned Standing Counsel, Panchayat, as well as Mr. S.S. Roy, Learned Counsel, appearing for the state government advocate, appearing for the other state respondents. So, Mr. S.S. Roy shall, on the next date of listing, place before this court the basis of passing of the order dated 7/8/2024, impugned in the present proceedings. Also, qua the earlier directions passed by this court in the proceedings involving the subject matter involved in the speaking order dated 7/8/2024. Also, the matter be listed again on 21/8/2024 for motions. Prayer for interim order would be considered on hearing the submissions after Mr. Roy has made his submissions in the matter upon instructions. On Wednesday, you get your instructions. We'll finish it up that way.
Oblige.
Yes, anything, Mr. Gugoi?
Lordship.
I just tell me whether we can help her, how we can help her. Any way out?
No, no, anyway, Lordship, because of direction is because of Lordship, Honorable High Court direction is there, Lordship. We have already framed a new guideline. That's why we are helpless.
But what about your discretionary quota of your chairman and vice chairman? 10%, 5%?
Could not comply the discretionary or quota.
Why?
As because no new construction is arises in entire Guwahati city, Lordship.
Lordship, this is totally injustice because I have applied in 2007. Then again, I have applied on 2012.
But madam, I'm sorry because there is in between, there is an order of the division bench, basing on which they have already formulated a guideline.
With this order, they have, in this order, there is no mention that, about cancellation. And also.
They have brought it, I think, in the,
From the guidelines.
no, they have in the guidelines, they have mentioned that in clause 13, page 43.
Lots.
Because I can't pass an order which would, I can override this guideline, but I can't go beyond the division bench order, the order of this court, coordinate bench. Right?
Yes, Lordship. Lordship, they have mentioned in their instruction that at present there has no new construction is Greater Guwahati for allotment. Kindly consider me when
That is real.
when there will be new construction.
Okay, do one thing.
Lots.
She'll submit an application. You have a list still, or it's exhausted?
Already adjusted.
Adjusted. She'll submit an application. You keep her in the waiting list. You keep her in the waiting list. Whenever the new construction comes,
Yes.
include her name also in the lottery system.
Lots.
Right?
Lots.
Include her name also, include his name also in the lottery system. Bring it out, give it, we'll give some observations. Right?
Whenever new construction is come.
But she'll submit an application
Yes, mine is-
within
Let
15 days from
let
today.
the petitioner submit an
Application within 15
Whenever new
days from
construction
today.
is come up,
That application, we'll be keeping, any form is there, she'll fill it up. That application you will keep. Whenever the new constructions come,
mine
you
is
will
right,
also put her in the lottery system.
lots,
Yes,
Huh?
lots,
It'll be lottery only.
lots.
And you make separate applications for separate categories. We'll provide for that.
Lots.
At 2 o'clock, I'll pass it.
Sure.
What was that, Dilip? The written arguments are here,
Yes.
but Mr. Kejriwal, I'm not taking up the matter today because I'll not be here from tomorrow onwards. I'll fix the matter on 9th or 8th or 9th, 9th or 10th. 10th we'll put it. And on that day we will hear it because now both of you have come up guns blazing. The matter was heard in part. The petitioners as well as the parties have brought on record their respective written submissions. So further arguments would now be required to be made basing on such written arguments brought on record. Also, accordingly, raised it to list these matters again for further hearing on 10/9/2020.
Obliged. Obliged.
Mr. Mannan,
Yes,
you are the petitioner in 7852/2018.
yes, the second one I am the petitioner.
Okay.
First one,
Now, if you come to your prayer there. The settlement that was made in favor of the petitioner, Suren Talukdar and his wife, is not under challenge here. Just something. Here, it's qua the eviction proceedings.
Yes.
So nothing against him.
not,
So we cannot go and examine whether that settlement which you have brought on record, whether that settlement was made in a proper manner, was following everything, that we cannot examine here. So we'll have to hold that Mr. Chaudhary's settlement is not under challenge in this process. So DAG number 100 converted to 108, Patta KP Patta number 9 remains.
no, that what why I'm brought in all this.
I know that.
Oh, yes.
You know that. I know that. Now, you admittedly continue to be in DAG number 100, which is a government land.
No, there is a issue there. I'll come to that.
Ah.
It cannot be said to be a government land. They have themselves.
No,
say-
no, they have brought the SITA also. SITA also, it is written as.
Yes, I'll also show them the affidavit as well as the
I'm
documents
trying to
that
find
they
out-
have
I'm
produced.
trying to find out a way. We can middle way.
Mhm.
So, land of Mr. Suren Talukdar, we cannot go into. So the only thing we have to see, qua Suren Talukdar, is whether the construction activities you have taken up violates any of his rights,
Yes,
because the reports say that you have even entered into his land by way of that construction. So this petition will depend on the outcome of your writ petition.
my
If
submission
we
here.
uphold that they have the power to proceed against you
Yes.
for eviction, because it being a government land,
That I'll have to submit.
that we will have to hold them. If we come to that conclusion that we can, that they can, that's the end of the matter. But you have also made an application for settlement of that portion of the land wherein you are still possessing. Now they come up and say that we can't do it because the demarcation is not there, forest land.
Yes.
Then my question to Mr. Goswami now would be, Mr. Chaudhary, you can take your seat. We have nothing against you. Yes, Mr. Goswami. How did you make a settlement with Mr.
Yes.
Suren Talukdar? If that
No,
land,
even then, your lordship, their eviction notice also cannot be made because they have not demarcated, your lordship.
fine,
That is, this
we
is
will
my,
come to that. How did you make that settlement with Mr. Suren Talukdar? If the land, same DAG, 100, after that settlement, it was converted to 108, but the DAG is same, right? DAG is same, it
Yeah.
got converted to 108
it was 100, it was converted
to 108. 100 remained. This portion, 1 katha something, went to 108. Yes, Mr. Goswami, how did you do that? This is the answer I want. That's all. Then everything will be falling into place. If you don't have an answer for that, and if you say that you have been saying that that is proper, then consider his case. If that land is forest land, what authority does the circle officer have? We agree that the circle officer has the power of, because that 2010 amendment is there. So he has the power of issuing eviction notices. But if that land is forest land, what right does he have? And how did you settle forest land with Suren Talukdar? What is your answer? Why? Filed so many affidavits, these small issues are not dealt with.
In fact, your lordship, I just point out, the first affidavit they have filed, they said that there is no record at all available. In fact, in the court, before your
No, if
lordship
the-
has
my-
come,
my-
they have
my-
said that.
my-
And
my-
the court
my-
also wanted
Mr.
that.
Mannan?
Yes,
Your rights would emanate for a consideration Because you also admittedly, nobody is disputing that you are occupying 100 Dag as it stands today. Right? You had occupied 100 along with Mr.
Yes.
Suren Talukdar.
No, we have the next door.
Next door.
Yes.
So 100 got bifurcated. Dag got bifurcated because one a settlement was made, a patta came into being.
We came in up and said that you settled with him, settled with me. Then they say you cannot do it.
Yes.
And I said then cancel.
Mr. Goswami,
This everything happened.
what
like
time? 2 o'clock.
There is
Get that instruction.
There is a question, my lord. If settlement is done, my lord, I don't have any objection in respect of him. But the enforcement that is.
That we will go into.
Yes.
Because if that settlement cannot be done, then Mr. Mannan along with his constructed property will be evicted. So there is no further requirement for examining your claim here. But if Mr. Mannan can be settled with that land, because you were settled also by occupying the same land.
My grievance is no side margin has been.
Will. That is the second issue.
No,
Once
that
we hold
issue
that
also,
here-
your lordship, that issue also, I'll just make one submission. What has happened? This was, the construction was not made yet. In fact, the pillars were laid, your lordship, I raised, and then ultimately.
It was
shuttering-
stopped.
Shuttering was done, the stay order was. Now for 6 years, there's nothing is there. They have dismantled it. If your lordship wants, your lordship can direct them to verify. It has been dismantled. it.
That we will verify, provided we put you there.
That part will also be settled.
No, we put you there. We hold that you have a right there to be there. If you have no right, you along with your whatever is there is gone.
I'm
Will
there
be-
for 44 years.
Fine, Mr. Mannan. So now you clarify as to how from that same Dag, you could give it to Mr. Chaudhary. But when it comes to Mr. Mannan, why this plea is taken that you have no records? If there is no records, 100 could not have been bifurcated. When?
Next week.
2 o'clock, that much only.
Next week.
From the circle officer, just make a
Next
phone
week,
call.
because-
Because your affidavit in Mr. Mannan's case says you have no
Look,
records. But then how did you make it? It's not very old settlement that has been made with Mr. Chaudhary, proximate to the filing of these cases.
next week.
But Mr. D.N. Chaudhary, D. Chaudhary, as well as Mr. Y.S. Manna, petitioner, learned counsel for the petitioners in WPC number 4591/2016 and WPC number 7852/2018. Mr. N. Goswami, learned counsel, appears for the state respondents. Mr. N. Goswami on this court had queried Mr. N. Goswami as to how the settlement in respect of Dag number 100 possessed by the petitioner in WPC number 4591/2016 was so made by him, and the portion of land so settled of 1 kata 10 lesser being thereafter covered by Dag number 108 and KP Patta number 9. Mr. Chaudhary, KP Patta number was after settlement? Seven. KP Patta number 7. So, however, in case of the application for such settlement made by the petitioner in WPC number 7852/2018, it is the stand of the respondents that there is no record pertaining to the status of the land covered by Dag number 100. Full stop. Also, the specific stand of the respondent authorities in the affidavit is that the circle officer White letter dated 2/3/2018 after inquiry had stated that there was no survey of Jansimalu NC village and no trace map of the area. Therefore, dark number of the petitioner could not be identified. It was also stated that there was no demarcation between the land of the village involved and the forest land. So if above be the position, it is not understood as to from the same DUG, that is DUG number 100, how the petitioner in WPC number 4591/2016 was given a settlement in the matter proximate to the time when the present proceedings were so instituted. Mr. Goswami shall place the above instruction before this court on the
22nd.
on 22.
22.
Mr. Chaudhary, any 21,
Which is 21, 22nd I will not be.
21 on 21, 8/20. 21 is any problem, Mr. Chaudhary? 21/8/2024. This is the plea that they have taken, that proximate to that application, your application was allowed from DUG number 100, then everything was okay. There is a trace map also wherein it has been showed after the settlement as 108.
Yes.
But now they say when he submits an application that there is no survey of that area. How can they have two stands?
If the particular area is not demarcated, Your Lordship, they could not even
We-
issue a notice.
No,
to
there is an affidavit, there is a trace map also.
After filing of my application, he had to remove, there was a notice for removing his encroachment. And then he filed this petition as
We'll
if
see.
he has challenged my.
Because
settlement. I have
that-
no objection
no,
if he
Mr.
settlement.
Mr.
No,
Chaudhary,
that-
we are,
that we are also
Mr.
not
Chaudhary, we are not concerned whether he settled with that plot or you are settled with that plot. We are only concerned with the yardstick. When your plot was settled, everything was proper, trace map was there, everything was there.
Yes.
100 is shown there. I think it's on record.
Yes, yes, yes.
It's there on record. There is an affidavit. And therein a trace map is there. I think you have brought it on record by way of an addition.
By additional evidence.
Ah, yes. Yes, page.
It has been
60.
included in 108.
So 108, 100 is a very big DUG.
It's a big place, Your Lordship.
So from there, 100, if you come to page 60,
Yes, I've seen that.
then that 108 is written there. So it was admittedly a part of 100,
100.
demarcated, 108 given. So if 108 can be given, why you say in his case that there is nothing? You have a
And
trace map
they-
also.
They in fact proceeded in my favor. Later on, they came up and said, no, I can.
Get your instructions. We're only to that extent. And thereafter we find that he can be accommodated. Then the question of removal and all those things will come.
Remove.
Full stop. Further, the circle officer, Dispur Revenue Circle shall also submit a report with regard to the present status of the constructions made over the plot of land possessed by the petitioner in WPC number 7852/2018. You say everything is gone.
This is practically
No,
gone.
no.
I have also photographs. I would have provided.
Now we'll have the report from the.
Let them go and see.
Okay, fine. 22nd.
In
Hope on
fact, what has
22nd.
happened, in their prayer, my learned friend has said that we had nothing against you. In their prayer, they specifically prayed in that petition that action should be taken against me because I am holding a government. That is there. And then after that, they have
Only because of the encroachment.
And you
But
have
you-
also,
you-
you
you
have
are
also
adamant
made
that you are not
allegation
to remove it.
against that man,
That is why you
saying that he is a habitual of filing of
Yes.
cases.
Now, this is both neighbors, your lordship, they are having a lot of problems.
Then
I wanted them to settle it, but they are not settling.
we are not on that. We only want whether the yardsticks have been applied equally. That's all.
Exactly. I am not against them.
Okay,
In
fine.
fact, I wanted them to
Mas-
settle the matter. Anyway, much obliged.
Respondent number 7 has filed the affidavit, my lord. The affidavit of respondent number 2 and 4 is required, my lord.
Forget it. Now tell me your right after this speaking order. Borpeta got divided by BTC
My lord.
Act. Now those total majority of that tribal subplan area falls in PTC area.
My lord.
So it is up to the government where they place it. BTC, how can they, BTC has no objection here.
13 pages are still there, my lord. 30 villages
Fine.
are-
196 and 30. It will be better. It goes to an area where 196 can be covered, 166 can be covered.
No, still there, still the.
What is your right?
Certain
These are
benefits-
policy
no,
decisions.
these certain benefits are
If
there.
there is no mala fide LH, you have that's no mala fide.
No.
How can we go into it? Whether the office would be here, first floor or second floor or third floor, that is the discretion of the authority empowered to do that. Until and unless you can show that, see, there is no stay order here.
No, no.
The officers have been shifted.
No, as per this affidavit, my lord, this office still running there, my lord.
Yes. Where is the office now?
What you will see paragraph 5 of the affidavit filed by respondent number 7. Paragraph 5 of the affidavit filed by respondent number 7, my lord.
Mr. Goswami, just have an instruction where this office is functioning as on date, because there is no stay order.
Sure.
And the speaking order wanted immediate shifting.
Sure.
Huh?
Sure.
So we just want to know where the office of the project director, ITDP Borpeta is functioning. Get me at 2. Just have a phone call. 2 o'clock.
Obliged.
Yes. What is your
I'll
instruction?
Have a lordship.
Huh.
Please,
Okay,
at 2
after
o'clock,
some
sir.
time.
2 o'clock. Lordship.
After. Yes, Mr. Goswami. Yes, madam. What is your instruction?
Instruction is received, lordship. Forensic report was done, lordship.
Okay. Investigation is nearly complete. They are submitting the final form. We'll close it. Also. Heard Mr. K. Kolita, learned counsel for the petitioner, also heard Ms. S. Borwa, learned counsel appearing for the government advocate appearing for the state respondents. The petitioner in the present proceedings has raised a grievance with regard to the slow in the process of investigation in connection with what is the FIR number? FIR police case number?
3570/17.
In connection with Dispur PS case number
Case 45, lordship.
case number 3570 of 2017 under section 120 bracketed B oblique 420 oblique 406 oblique 468 oblique 471 IPC lodged by the petitioner herein against lodged by the petitioner hearing. Also, on the last date of listing, Ms. S. Bora was directed to receive instructions with regard to the progress so made in the said investigation in the said police case. So, Ms. Bora on instructions has submitted that the investigation is nearing completion and the opinion of the forensic science laboratory with regard to the materials so seized and sent to it for opinion has also been received, and the case is now pending for submission of final form. So accordingly, the investigation in the matter having reached its conclusion and the stage being now and the stage now being set for finding the FF in the matter, final form in the matter, this court would not be required to further adjudicate, no further issues arise for adjudication in the present proceedings, and the writ petition and the investigating authority is directed to conclude the investigation in the matter and submit the final form at the earliest. Also, with the above observations, the present writ petition stands disposed of. The instructions received by furnished by Ms. S. Borua, learned counsel, learned government advocate, appearing for the state respondents, is kept on record and marked as X.
Hello.
Right? Yes. Borua, no? Borua. Yes, when are you paying?
Lordship, we have not received our instruction. Your
2 o'clock.
Lordship, from department, they have sent us the letter.
What? Oh. Why so late in informing the authorities? Hmm? We don't know. We only want the instruction when you are paying him, and if he is due. We'll have the matter on 22nd, you get your instructions,
Lordship,
written instructions, right?
Lordship.
Ms. N. Bora, learned standing counsel, Panchayat and Rural Development Department.
J. Bora.
J. Bora, submits that the instructions are sought for by this court, white order dated. Instructions as required to be received by her in terms of the order dated 12/8/2024 has not been received till date by her, and she prays that the same would be furnished on the next date of listing. Accordingly, raised it to list this matters again on 28/8/2024, on which date Ms. Bora shall receive written instructions with regard to the date, with regard to the dues receivable by the petitioners herein, and the date by which the same would be so released to them. We are ignoring your this thing, but we want that. You get a written instruction. 22nd.
Oh, bless them.
Yes, Mr. Bora.
I have not got any written instruction, Lordship. Well, I'll get the instruction that it says the payment has not been made. Part payment has not been released, madam.
That's it. That's why we wanted it.
Lordship,
Obtain
fix it
instruction,
in-
the stand taken that a petition
Lordship-
has not been paid is contrary. This was
Lordship,
in
fix it
June.
after 10 days, man. In the meantime, I'll get that.
Make a phone call.
Why? Oh, my lord. Because they are old matter, because 19, my lord. That's the.
That's what I'm saying. Why this delay? It seems from the materials
It has
brought
not
on
been-
record,
not been listed for a long time, my lord. That's a.
it was there on
Yes,
26,
sir, thereafter-
7 last month,
Last month, my lord. After.
and it was fixed today at your prayer.
But I will not. After 10 days, Lordship, we'll get the everything.
Mr. S. Bora, one more day. Mr. S. Bora, learned counsel appearing for the respondent submits that he would place the instruction. He would receive instructions as to why the petitioner has not been paid his contractual dues, contractual dues. Also, as a last contractual dues, also prayer accepted, raised it to list those matters again on 29/8/2024, on which date invariably Mr. Bora shall receive instructions in writing from the competent authority in the matter and place the same before this court. Failure. Place the same before this court. Also, Dr. P.K. Goswami, learned counsel for the petitioner is present.
But see, in this matter, I have received a letter praying for some more time, Lordship.
No, I want more time for payment. For payment, if you pray that I want some more time for payment, full amount with interest,
Yeah.
I'll grant you.
To take instruction when the payment has been made. For that instruction, some more time, short accommodation.
Within the course of the day, I want that before I rise. I only want that date when you're making, because it's an admitted day, you can't go beyond this. We'll not permit you to get the orders of the court nullified like this. There is an MSCT award against him. You paid 50%, then you withdrew it, not paid. You take up a plea that the petitioner is not to be. Petitioner is before me. You are the state. If the petitioners are not there, file a report that petitioners have left India. So we are not required to pay anybody, and I'll accept that. You have not even done that. The affidavit in opposition also does not dispute the MSCT award. You have not filed an appeal in the matter. There is an order of this court also, division, there is an order of this court. 3 months, the money was directed to be released. Now it is getting complicated. We'll not permit this thing happen. Our orders, this order is of 2005. Here, 19 years down the lane, you have not paid the money. 2 o'clock, whoever your authority is, or next day I'm calling you.
Sir, kindly fix next.
Sorry, madam. Last occasion itself, I told you very clearly that
Yes.
if I don't get that date, I'll take adverse action order. I'll pass adverse orders. And I'm going to do that. At least the decision that I take, if I don't stick to it, what is the beauty of me sitting here? 19 years you don't pay. And you want us to be accommodating you all along because you are the state. Is that the submission? Can that be a submission, madam? 2 o'clock or 3 o'clock, your authority is coming here. And we will ensure that the check is issued. 2 o'clock, you get that instruction. And madam, it should be a very reasonable time.
Yes.
2 o'clock. Mr. Das, how can I help you here?
So,
The affidavit that has been filed, there is a dispute.
there is an admitted by them.
No. They say that we have not given you any orders to that. That's a complete.
They have.
Once there is a dispute, madam.
They have paid money. Where is the question of dispute?
Okay.
They have paid.
What they have admitted is 6 lakhs, right? 8 lakhs bill was
They
there.
will raise where dispute, my lord.
Mr. I'm not on that. You come to page para 10, 110. In my writ jurisdiction, if you can show me that I can go beyond the admission also.
My lord, I will tell 2 things. One is disputed question of fact cannot be entered by this court.
That's it.
It is disputed question of one has to go before the appropriate court. But here is a case is a different. Disputed they have raised, when they have raised the disputed.
Fine.
Disputed raised later on. But they have admitted by their own department that number 1, there is an approval. Number 2,
Who was the authority?
let's see that, my lord.
Okay, show me.
Their own person.
Hmm.
It is
Show me.
not by somebody.
No,
else.
Mr. Counsel, there is a
So who made the payment?
Tamsher
No,
Ali's case.
Tamsher Ali is different. Who made the payment here? There is a payment has been made to me. My lord will kindly first
Okay,
see.
first that you see
My lord,
page. Okay, you show me what you want to show me.
Please see page 22 first of my writ petition. This is a construction.
Hmm.
My lord have seen, construction rural road, culvert so and so.
Hmm.
Amount which is indicated 7 crores 98,598.20. Now, my
And
lord,
it's also admitted that you have completed around 83% of
right,
the.
agreement was executed
Hmm.
at page 23.
Hmm.
Now thereafter. at
Scope of the work
final
was changed.
order At page 82,
82.
final, page 82, final work order was given
Hmm.
at page 82.
Hmm.
Then at page 83,
Hmm.
construction of causeway
Hmm.
over river. So they brought this in 2010. But
Hmm.
the additional director designed written to the executive engineer.
Hmm.
Kindly see the drawing and design of general arrangement, cross-section detail of the.
Now
amount
show
of
me
causeway.
show me the technical approval
No, now. kindly
and
see.
sanction, technical sanction and administrative approval for this, page 83.
Please look at it, if we then I will.
I have
Just
seen it.
The basic design, the drawings are approved after necessary modification, correction in so and so. If you turn to page 84, this is estimate of vented causeway where it is approved. Kindly see on the left hand side, it has been approved.
Mr. Das,
my lord-
one factor. This they say is the proposal. It's not the approval.
Now I told. Now please see 85.
Hmm.
Now they want
whole work, because what they have done at page 86.
Hmm.
If you see 86, now as the causeway, when causeway was 2 crores something, so totally work estimate, kindly see my note,
Increased.
it becomes 10 crores.
Hmm.
Because initially it was 7 crores, so it is 10 crores.
Hmm.
Now at page 87.
Hmm.
Report, now see the third paragraph.
Hmm.
Construction above road is most important people of so and so. In this, there is a new provision of vented causeway covering length of so and so, against the artwork only exceeded of so and so. Now this is an abstract of cost at page 88.
Hmm.
Now at page 89, which is most important, kindly look into 89.
Hmm.
Executive engineer written, with great displeasure, I am to inform you, despite of repeated requests, you have not paid attention to complete the above 10 work within the extended progress of the work is only 83%, where your lordship indicated also 83% of the work has been completed. Now, in the meantime, there was some development where they want to forfeit my bank guarantees.
That they have
we came
withdrawn.
up before the High Court.
That they have
Page
withdrawn.
91 kindly be looked at. They have withdrawn because of the matter, court case matter. We came to the High Court. Page 91 kindly be seen, my lord. This is important. To the chief engineer, addressed by the executive engineer. My lord, that cannot be ignored, which is addressed to the chief engineer. Detailed report of causeway, so and so. Kindly see the first second. After drawing and cost of when causeway was prepared and approved, my lord will kindly see the word from your end on 29/2010. Accordingly, the causeway work was achieved almost 70% of progress. But the contractor stopped the work due to non-approval working estimate of the whole project. Because as it was 7 crores, it was increased, 2 crores was increased. So they want to get approval of whole project. This is a letter addressed by executive to chief engineer. I just want to putting a question myself. After 2016, what is the response of this letter of the chief engineer? When we came to the court, when the court wanted to know what was happened, we want to see where your rejection. Then only they come with an affidavit. This is an admitted position, a letter by executive engineer addressed to the chief engineer. 70% of the work of progress. And my lord, kindly see the word in page 91. Kindly see at 91, my lord. Once again. 91. First, after first 5 lines. 91. So far as discussion, Lord Gautam, my lord, let us see. With refer to subject, I have the honor to inform that the so and so, with a provision 2 number of RCCBs. But at the time of execution, it was observed that so and so gap was occurred in the 2 said due to change of course of Patanga. So, as per the discussion and site verification with higher authority, a causeway was proposed. After the drawing and cost, BOQ of vented causeway was prepared and approved from your end on 29/2010. Can they say it has? My lordship is asking me, where is that approved? This is approved by their own statement.
So Contract Act
Yes,
76.
section 70. That's
70.
I remember when this question came up, your lordship indicated about 70. That's they have. My lord, now kindly see.
What is your reply to para 710 of their affidavit?
I'm sorry, my lord.
Para 10 of their
Oh,
affidavit,
yes.
your reply?
Para 10, my lord.
Your reply? That is at page 120.
120.
20.
Or my reply.
Hmm.
Your lordship is para 12. Your lordship is
Para 14.
para 14. That a statement made in terror
10.
are denied by answering respondent. And state from where
You are referring back to page 91.
it is apparent that drawing of causeway and cost of vendor was prepared and then approved by respondent number 3. And that too after due discount site verification by respondent number 3. Accordingly, causeway work were achieved almost 70%. Entire new working estimate was also submitted to him. Respondent 3. Deponent has completed 70% of vented causeway as per approved plan estimate. He is entitled to receive payment thereof. Although some payments have been made for the work of vented causeway, but the deponent has not received the entire bill of amount of 70% completed work of causeway. From the facts that the deponent has executed work of when causeway itself shows he has executed the work as per modified the scope of the work as per instruction of respondent. As such, his still entitled to receive an amount as admitted by responsible authority by statement prepared by so and so to the additional. Moreover, the response we have not denied
Okay,
to the.
I've got it. Their case is that, see, we have not given technical sanction or administrative approval for this causeway. So it was up to the level of the, from the page 91 to the level of the chief engineer. It did not reach, normally the project is to be approved by the technical sanction by the government. It was not there. So they reverted back to the earlier procedure saying that we have considered 6 crores of order there, we have paid you.
Correct.
Then you in the reply say that, no, there is another 1 crore something bill prepared. Why have you not released?
Yes, sir.
The executive engineer cannot release because the fund is not there, because the approval of the enhancement of the project. If that be the
Now-
situation,
Yes, now.
the factum that this work was being done by you with the approval, because you stopped the work because there was no administrative approval.
Now.
You
yes,
rely on
right,
91,
your lordship is right.
you rely on
Whole
91,
work-
whole
Whole
work
work has not been approved.
approved.
Whole
So,
work, whole
so
work. Now,
you proceed against the
now-
executive engineer, he'll be
now suppose there is no work order. Let us say there is no work order.
70.
But 70.
But for that, we'll
I-
also have to have
I work and they have utilized.
70, there is an admitted that this is a work which is being done. That is being disputed here. The very factum of the work is being disputed by the government. The authority to who is to do the work. You have done some work, 70 would come in. But the factor here, which is troubling me, is the denial.
No, my
So
lord,
it's a case when
Where-
there is a denial in
No,
the
no.
affidavit, can I go beyond
your
that?
lordship has to look into one aspect of the matter. When it was denied. That your lordship has to look into it.
Fine,
But my lord will not ignore the letter, but there is no
the,
response. 2016, there is a letter by the executive chief engineer, and there is a letter which has been written that your office has approved.
fine.
So is
But,
there
but,
any
but
letter?
Mr. Das, there is also an admitted position which comes on record that the government had never given this sanction.
I'm sorry,
Government had never given this sanction for this work.
my lord, government make it, this is done at the level of the chief engineer. Chief engineer knew it, it's a government, they are a part of the government.
Technical sanction, estimate approval,
My lord,
everything is by
just
the,
recollect one order. There is a case which is dealt by this court. And this was a case where there was never an order of blanket. There was never an order of blanket at that relevant time.
but you made
During
the supply.
Congress time, I had to put the Congress. Thereafter, the government changed, BJP came. Thereafter, we came up before this court and we said, even if there is no work order also, you have received and you have utilized it. Once you have received and utilized it, then section 70 comes into play. Now there is a denial by the BJP government.
Here,
There is a government, they said there is no work
we are
order.
not going by the government.
No, no,
Here
but
the
there is no
problem
work
is,
order.
here the problem is, you have done the work, but the utilization is not there because it cannot be utilized because the work is not
No,
complete.
that is only a procedure irregularity.
Yes,
It is
Mr. Nayak,
regularized.
what do you have to
It is
say?
regularized.
Lordship, the original contract was signed with the chief engineer. So it will be the chief engineer only who would give him additional work order for executing
I'm sorry
additional
for
work.
troubling your lordship. One second. We got it. This approval is full-fledged approval is there.
From
Chief
whom?
engineer for Vent Causeway also. Chief engineer, all the authorities concerned. I will show it before this court. There is an approval.
Your, that
But
statement is gone.
my stand is
Yes.
different. Lordship,
See,
kindly
that
see
is-
my affidavit,
this is
Lordship,
the
paragraph
approval
4.
which is done.
Page
No, your
page-
affidavit is weak.
Page 108, not vague, Lordship. It is specific. Page 108. Page 108.
Hmm.
Paragraph 4, third line. The decision to set up a vented causeway covering length of 550 meters instead of outships as mentioned in the writ petition was not final. So the concerned authority rejected the proposal and
Who is that
estimate-
concerned authority to reject that proposal?
Let me obtain it.
Why in your affidavit it is not reflected? You have set the whole earth here.
No, authority, chief engineer is not the.
No, you
final
say it
authority,
because I have a document now which says that the chief engineer has approved the design.
Chief engineer only approved the design.
Fine, but
Let him
what,
place the contract
but
then,
where
Lordship.
is that, what happened in between the design approval and the rejection?
I'm coming to the next paragraph.
No,
Lordship.
no, you tell me from this paragraph, it's
That
not.
is, that is paragraph 4, it was rejected.
So
My
the
side,
concerned
it is
authority,
rejected.
you say the concerned authority is the chief engineer,
Yes, he has
right?
rejected.
When has he rejected?
Then Lordship may come to.
Okay, okay, just a
Lordship may-
moment, just a moment, just a moment. We'll come to that. Okay. Okay, where is that estimate rejection? That is page, this is an estimate of 24/1/2011, which was rejected,
Lordship.
right?
Right.
But the subsequent proposal was submitted by the executive engineer at page 91, wherein it was held that the chief engineer had approved it. Now you also admit that it's the chief engineer who is to give this approvals. Page 91.
So this was earlier date, Lordship. Earlier, if this document is to be admitted also, Lordship, this is earlier, approved on 29/2010. But it was
No, no, no.
proposal of 24/1.
No, no, the letter of 2012-16 at page 91.
Lordship will see the date on which it was approved. Approved from your end on 29/2010.
Huh. And the proposal had gone.
Then subsequent proposal was on 24/1/2011.
And then what is this 2016? If that rejection was there, Mr. Nayak, let us hold that in 2010, the design were approved, 2011 estimate prepared, given, rejected. Then why in 2012-2016, your executive engineer is not referring to that rejection?
But this affidavit has been filed by the executive engineer himself, Lordship. Oh, sorry, this is chief engineer. Then Lordship may please come
The
to
chief engineer.
paragraph 5.
So
Lordship.
where is that, Mr. Sharma, where is that paragraph pertaining to page 91?
Thank you.
Which paragraph have you dealt with? Page 91, annexure 8. Okay, let us see.
11.
Para 11.
11.
Come to para 8 of the page 110 of your affidavit.
That clear, Lord.
No, it's vague.
That is why I'm coming to paragraph 8. Lordship.
You have said everything but not said anything.
No, it has not been explained, but statement is there at least.
We'll have to have that. He has
Then
made a
Lordship may
categorical.
please come to paragraph 5, Lordship, page 108. Third line. From the security of the office record, it is seen that there are no office record to issue instruction to the petitioner to execute the work of contract as per new plan, estimate including Vantage Causeway. Therefore, the claim of issue of instruction to the petitioner to execute the work per new plan, as per new plan, and estimate is totally false and imaginary. So no such instruction was ever issued to him. Let him place that, Lordship. Any contract, any instruction.
Okay. Heard Mr. D. Das, Learned Counsel for the petitioner. Learned Counsel, Senior Counsel, assisted by Mr. P. Sharma, Learned Counsel for the petitioner. Also heard Mr. P. Naik, Learned Counsel, appearing for the PWD respondents. Also, while the entitlement of the petitioner herein to receive the amount claimed in the present proceeding is disputed by the PWD authorities by way of filing an affidavit. Also, it is the contention of Mr. Das, D. Das, Learned Senior Counsel, that the respondent authorities have not responded the manner in which the communication dated 2012-2016 issued by the Executive Engineer PWD Nalbari Rural Roads Division Nalbari was dealt with, and perusal of the said communication shows that the petitioner had carried out the work after the approval of the same was so received. Full stop. The affidavit so filed, while bringing on record a contention to the effect that the estimate so submitted after the earlier design was modified on 24/1/2011 by the executive engineer PWD Nalbari Rural Road Division was rejected, was not approved. However, a contrary picture comes on record on perusal of the said communication dated 2012/2016. Mr. Naik shall receive instructions as to the purport of the communication dated as to the purport of the contentions made in the communication dated 2012/2016 and the steps taken by the chief engineer PWD Roads on receipt of the same. Full stop. Mr. Das, Mr. Sharma, P. Sharma, learned counsel for the petitioners, shall bring on record any order oblique direction issued by the competent authority for carrying out the works as per the modified drawing on the next date of listing.
Yes, drawing is there.
No, this is approved, but there has to be an order. This is not with you. This is not with you. Asen, there is an order.
No.
You just get that.
And there was some instruction, one order passed by this court. They said it was rejected. The court said that if there is rejection, please produce before. the court.
Also, Mr. Mr. Naik shall also produce before this court on the next date of listing, the decision either taken in the file or by way of a written communication, rejecting approval to the estimate, proposal and estimate submitted by the petition by the executive engineer PWD, Nalbari Rural Roads Division, vide his letter number 3532 dated 24/1/2011. If we get it, otherwise we'll ask Mr. Das to go to the civil court. But if these are all approved, then there is a further contention that 1 lakh something is being prepared. Bill has been already prepared.
No, not.
1 crore, sorry.
10
1 crore, 10 lakhs.
By
You have to
their
release that to him.
By their department,
You will have to release that to him.
By
Just
the
get these
department.
instructions.
And
Both of you.
And only after the court's order, after when we filed the writ petition, they had a meeting with us. And we sat together, all of them.
Now you have that in the reply you have brought in.
Yes, I brought it.
Get
They
that.
did not spend
We'll
anything
see.
about that.
We'll see what
Yes,
where we can.
deeply obliged, man.
List this matter when? Mr. Das, when?
3 weeks. left.
28, they want some.
Hmm?
28.
28. 3 weeks. Why
Next
3
month.
weeks?
I'll get some time.
This is-
Why?
now.
You only have to bring on record the material you already have.
My only concern is that I will have to compromise with my other commitments, Lordship. That is my only concern.
What other commitments?
Instruction in other matters too.
This you write a letter, they will
Lordship, please
automatically.
consider, Lordship.
Today
weeks,
is,
Lordship.
today is 16. We'll have it on 30th,
30.
30,
This month. This month.
this month 30th,
Yes,
38.
deeply obliged.
Lordship has just now disposed of matter item number 23. I think Lordship, the respondent has wrongly submitted some report. It
Wrongly, no, Lordship, it
was,
May I please,
Lordship peruse the report, Lordship, in respect of some Gohin Pegu,
was a
it's a
instruction.
trapping case. Case number is right. But its contents, Lordship, peruse the contents, second page. Lordship. Police case also required.
Oh,
It's a prevention of corruption act.
Mhm.
Second case, Lordship,
2,000 lagai dibo simple. 2 o'clock. Open it as 2,000. Dibo na lagi. What do you mean? Madam, get your fresh instructions by 2. Or I'll haul up your desk, man, for giving such.
Yes, Lordship, on last occasion, we have received the instruction, I have also placed that. There it is said that accused person was arrested in PS case number 3570, which is petitioner's case.
You get your records cleared up. If a wrong instruction was placed, place the correct information. I'll not
Yes,
go
yes,
into
yes,
it.
yes.
If this is the thing you do. I saw only the stuff I'll do some. instruction to go. Madam, go through this. This Deputy Commissioner of Police may be in trouble. No. He has given this instruction in 2718-2019 with regard to some other case.
2019.
2718-2019, that is the subject matter. Right? But here, second paragraph is with regard to something else. So please, I think he has made a mistake. Talk to him, get it rectified, give me the rectified thing in 2 o'clock. We'll not proceed any further thereof. Otherwise, if this is the thing you do, we'll ask him to be here at 3 o'clock to explain why he has done this. This will not be acceptable from a senior officer like him. That is what you want to say, Mr. Kolita? Okay, fine.
This matter affidavit yet to be filed. Matter relates to my lord.
Yes. What is this naming? Misdeclaration.
Lordship, Learned Counsel Vijay Sharma,
Call him.
is it,
We'll finish. We'll finish.
can it begin at 2 o'clock?
Oh, yeah.
2 o'clock.
It's misdeclaration. Goods released.
Books releasing and.
And what is the particulars? No particulars have been 15. They only said dues from 2015. Against which consignment?
Nothing, man. No.
Not permissible.
78 says, man, after delivery, my lord.
No, forget 78. If there is a misdeclaration, they have that lien. But that misdeclaration has to be declared that on this consignment booked on this date, these are the particulars. You have asked for it. They have not replied. Now, only thing is, this goods, all these goods came to Assam, or some of these goods went somewhere else.
Details are also not there, my lord. In which
If
connection?
the goods have not come to Assam, how will
My lord,
I have
all the
jurisdiction?
demands have been raised in Assam, your lordship. They are writing to us, my lord, in Guwahati.
That is no. If the transaction is between Bombay and Gujarat,
Details they are not giving, but my lord. our
we'll have the
address-
details, don't worry. Call Mr. Sharma at 2 o'clock. Mr. Sarab, what are you waiting for? Oh, those police matters. Has any instruction come? Mr. Goel, check up if any instruction has come.
Yes, my lord.
Instructions have come. Okay, we'll take it up the next matter.
That you know. Earlier occasion, your lordship was pleased to ask for some instruction from the government side.
50-51. Okay, let me see. As per decision, so and so, so and so, so and so. So and so, so and so. As per affidavit filed for decision, before only it is observed the actual number of ration cards held by the petition student as equal status record during the, however, subsequent to transfer of a few ration cards. So and so, the records part of disclosure rejected and renewed on. Okay, give him this copy. Anything you have to say? Give him a copy. Hey, 5 minutes होगा ना मतलब. So, on that day, you did not have 50. Less than 50, some cards came in, but that was unauthorized, it was cancelled. So, your thing remained in 41. You have not reached 50. So, in the reach, that has been clarified here.
Sir, I did wrongly clarify.
That has it been. We only want that if there is some wrong thing, drop proceedings against it.
Affidavit was sworn by the Superintendent of Police Board, Your Lordship. They have forwarded it to the Home and Political Department.
Okay. Home is also under you only, Secretary? This is the homes. Okay. What further processing has been done? The processing was already completed. The revised bill he has submitted. Government had sanctioned amount higher than that.
SP
When
board
did you, say, when was it sent? 38. 22. And from 22 onwards, this bill is being processed for last 2 years. Why was sent to the secretary to the government? Get me the correct instruction by 2 o'clock.
Lordship,
Why it takes 2 years? I'm nothing.
Lordship, in this
This 2 years you take to consider a revised bill, process a revised bill.
Yeah.
We don't want an affidavit. We only want to know why it is taking 2 years. Okay, if the government is facing complication in understanding, we will appoint a CA for that purpose if required. At 2 o'clock, you get your instructions. No, today, 2 o'clock. This communication is of 14/8 saying that on 38/22 this was sent to the government. So and so, in this regard, it is clarifying the steps so and so, that the matter of payment to the petitioners is currently under consideration and being processed. For the last 2 years, you're processing a bill, rejected, if it is so bad.
Actually, Lordship, very short period of time that.
Why?
has it-
What short period? 2 years is
No,
short
no, no,
period.
Not, I am not telling.
I'm
about
not
the
on
2
you.
years,
I am
Lordship.
with the government. Why is the government taking 2 years? I want that clarification.
Then Lordship, can it be on next day?
No, 2 o'clock.
2 o'clock,
Ask your, otherwise we'll ask your joint secretary to be here. What is this instructions being furnished? No application of mine. Do they think that we don't look into things? 2 years we are processing. I want the breakup of 2 years at 2 o'clock.
In the second case, there was no revised bill, there was your.
Originally.
Yes,
Second case, what is
in
that?
In that case also, Lordship, they have communicated same thing, Lordship.
What? When was the bill sent to the government?
The bill was November 30th, 22. Page 84.
Same thing.
Yes, Lordship.
They have to make the payment on the, they are just processing, saying.
No, I want to know what the processing is. Breakup at 2 o'clock. 2, before I rise. 2, 2:30, 3. By 3, you get me enough. I'll be satisfied. I want the breakup. I want to know how the government processes bill. I want to learn that. A bill taking 2 years in moving from table to table. Why? Either the bill should be taken, processed, rejected, taken, processed, paid. There cannot be a third way. Clarification can be a third way. You can ask for them. You have done nothing. Just kept the bills pending. Get it?
In fact, this is a fit case where they should pay interest.
That's the thought process we have. That is why this instruction is there.
Same not that within this day time, we will make the payment.
No. I want that first. I don't want another contempt petition before this court. You get that instruction.
Item 30.
And next time when they give instructions, ask them to be careful.
No,
They
actually,
want
Lordship,
time.
I got very short period.
Not
so
you.
In between, I have communicated.
No,
with
not
Lordship.
you, the authorities. There is a knack of making.
Because Lordship, matter is fixed today.
And for 2 years, what were they doing?
Something further processing has to be done from our side.
That's maybe the reason. Okay, 2 years, what were they doing? That much only I require them to give you a communication to that effect. break up. I'll pass appropriate orders, don't worry. I'll not put you into difficulty. But I want that instruction. Yes. Has this case been played? Have you made an application?
My lords, similar writ petitions came up before this court, and those petitions were disposed of, my lord, by order dated 19/7/2024.
Saying what?
Threat assessment reports, my lord, by the Commissioner of Police Assam was placed before the Honorable Court in a sealed cover. And my lord, it was found out that no specific threat as such was.
No, it has to be done by that committee. You have a committee.
Yes, my lord, SSRC committee state.
And what about this case?
This case also, my lord, the state security review committee meeting held on 21/1/22 and 31/1/22. It was found that
Where is that minutes?
minutes, my lord, we have not filed affidavit in the matter, but similar matters were disposed of with the observation that, my lord, with the direction that the responding authorities, in the event they are in receipt of such complaint by the writ petitioners, the authorities. will
Madam, I want that
assessment.
report.
Minutes, my lord,
Minutes, you give it to me.
minutes are not available.
Why?
with
Then
us.
what will I do with this judgment? This judgment specifically speaks that on assessment of the minutes
Yes, my lord.
and the decision, this order was passed. How can I pass an order complying with this? Is it a similar order to be passed here without those materials being made available? Then when? 2 o'clock
2 o'clock, my lord, not possible.
tomorrow,
my lord.
Monday,
Monday, my lord. Highly
Tuesday.
obliged, my lord.
Miss U Sharma, a learned government advocate, appearing for the respondent, submit that the threat perception, threat assessment of the petitioner with regard to the petitioner was carried out, and the same was placed before the constituted committee, which has rejected his claim for being provided with security, right? That's what you want to say?
My lord, as per the decision of SSRC meeting held on so and so, the PSO provided to the petitioner was withdrawn on 2/2/22.
Show me that. No, show me
Latest
that.
statement.
Your PSO has been withdrawn. And that is why you have done this. Okay, Ms. U Sharma, learned, government advocate, appearing for the respondent, submit that the threat assessment report of the petitioner, along with a detailed report, was placed before the SSRC as constituted in the matter, and the said committee in its meeting held on 21/1/2022 and 31/1/2022 on consideration of the same, had withdrawn the PSO provided to the petitioner hearing. Ms. U Sharma shall place before this court the said minutes of the meeting of the SSRC dated 21/1/22 and 31/1/2022. List this matter again on 28/2024. Produce that, we will see that, and then we'll produce. You keep this order also with you.
Para is comment, my lord.
I'm giving it back. Both order as well as the para is coming. Order it as I could order decision.
Meeting to,
Right here.
On 22 also.
22.
Highly obliged, my lord. Thank you.
No, 20, 20. 20.
Highly obliged.
My senior is on, let's see another court.
Yes, madam. What is there, Mr. Sharma? What is your argument?
May I please, my lord. My lord, though we have said the duty prosody of fund, but we have received some fund from the government, my lord. Specific direction may be given to us so that we can dispose of the same. We are ready to pay. We were not paying because of the prosody of fund. Since we have the availability of fund, so this matter may be disposed of with a direction to pay the requisite amount, subject to the verification made by the department.
Let her senior come, we'll pass
Yes,
on this. Whenever Mr. Sahiwala is free, let him come, we'll pass on this.
My lord, next item is also similar,
Okay, both.
as well as
36,
item
37
number
right,
71.
Huh?
As well as item number 71. supplementary-
71 to Rahit video.
Supplementary list. Obligation.
Yeah.
Yes.
This morning I have received one instruction.
Hmm.
It says that a report from the DC Nagaon has been received on 9/8.
Hmm.
So the department is examining the bills and it will take some time. The Lordship may kindly grant me some time to clear the bills.
Bills are of which
Like
period?
outstanding bills
Of
in
which
respect
period?
of,
2003 to 2005.
that is the difficult one. It's
Page 17 is.
So why only now after the filing of the case movement is made, not before?
Last two occasion also, they took time.
Madam? Yes, why it is
Madam.
delaying?
part of the payment has already been
How
done.
much has been paid?
It is
What is his total claim?
part of 4 lakh 15,950
Hmm.
has been paid.
Hmm.
And the balance is 661,214. Total amount 1077,164. So 4,15,000 paid and the 6,61,000.
Why it was not paid for such a long time?
Well, the report was not received from the office
Why?
of the deputy
Why?
commissioner.
Why?
It is received only on 9/8.
No, why it was not received? Why is the deputy commissioner not forwarding? Any enmity with the petitioner?
Because
And by
DC
this
is
time,
not a party.
many deputy commissioners have come and gone maybe.
DC is not a party here. Well, that is the.
Forget it. You,
Otherwise-
why did you seek a report for that? When did you first seek a report for that?
That
You are the
is-
department.
Yes, madam.
When did you first seek a report for that?
That is not covered in the letter, madam. That instruction letter, when it was sought for.
When will you pay the balance amount? Give me a date.
So they say they are seeking 6 weeks time.
No, we'll
To
not give you
complete the
any,
whole
we will
process.
not give you. We want the date on which you are making the payment. Process it. 2005 bills, you have not done anything. Person is waiting. Now, who will compensate the loss of money value? 2005, 2024.
Say the whole message before the matter is called up, but the person is found to be switched off.
Get hold of your chief engineer. This cannot be permitted. At least interest for a period prior to 3 years from the date will Mr. A. Bhattaji submits that he has received instructions in the matter that the bills of the petitioner for release of the area amount pending is under process and the same process. So, Mr. Bhattaji submits that the report as a requisite of the works, report pertaining to the works executed by the petitioner from the jurisdictional deputy commissioner was received by the department only on 9/8/2024, and accordingly a delay had occasioned. So, Mr. Bhattaji submits that the matter being now processed, a conclusion thereon would be reached and a decision taken as to the entitlement of the petitioner to the amount claimed by him in the present proceedings on or before 21/8/2024. Also, registered to list this matters again on 27/8/2024, on which date the decision arrived at with regard to the entitlement of the petitioner. With regard to the entitlement of the petitioner to the area amount claimed by him shall be placed before this court along with the specific date by which the said amount would be released to the petitioner here. List this matters again on 27/8/2024. Will do. On the next day, you will get it.
Lordship, kindly pass on the matter for the time being.
Have it on some other day. 24 matter. Okay. As prayed for by the Lanark Council for the parties, registered to list this matters again
Lordship,
on.
after break, for the time being.
Today, it will not be possible.
Lordship,
What is the urgency? No affidavits have been filed.
the earlier occasion, the respondent side has taken prayer to file counter affidavit.
You have filed your tenders in pursuance to the subsequent tender process.
I have to take instruction from a senior. Lordship, it will be taken as the last item.
Okay, second up.
May I please, your Lordship? Lordship, matter regarding non-payment of contextual bill, Lordship. Earlier I was filed a writ petition.
Yes, where is the instruction?
Everything, Lord.
Why? February
Not only only instruction I need to obtain,
is actually due to the petitioner, if so, the reason for non-payment.
no, one earlier order is there.
No, we are concerned with the subsequent order, 23/2/2024. That's the only order.
22/6/2022.
No, 23, what this is item number 41, Abul Qasim Mia,
Lordship,
WPC 9/19/2024.
page 57.
No, I'm with the order 23/2/2024. Second file to Duke November. You are paying for whom? Revenue? PWD?
Yes, Lord.
Okay. Page?
57. One order is already there, Lordship. For placing, considering his case in terms of considerably, Lordship. That instruction I have sought for.
That is exactly what this court required in the month of February.
Lordship. On the exit, Lordship, I will place
Okay.
his position.
Mr. P. Naik, Lanark Council for the petitioner, prays that he be given further 10 days time to place on record the instructions required to be received by him in terms of the orders dated 23/2/2024 passed by this court in the present proceedings. Prayer accepted. List this matter again on 6/9/2024. We are giving you more than 10 days. Yeah, but admission with that equally. phone আহিছে নেকি বনাই নি? Yes, none appears for the petitioner. You are for?
GST Lordship.
None appears for the petitioner on call. Miss,
N ka 42.
no, 42.
Item 42.
Where is Mr. Kar?
Is another next Lordship, code number 1.
Yes, have you perused the judgment?
My lord, yes, I have gone. Actually, this case is completely distinguishable from the other case where the learned.
Mr.
And
S.C. Kel, Mr. V.K. Chopra, learned counsel for the petitioner is present. However, Mr. S.C. Kel, learned standing counsel GST is set to be on legs in connection with the hearing of a matter. So, sir, Mr. Chopra submits that the decision relied upon by Mr. Kel with regard to the maintainability of the present proceedings is not applicable to the facts involved in the present case. Accordingly, he submits that this matter has to be taken up on its merits. Also, the issue would require some deliberation. Accordingly, registry to list these matters when I want you both together. When?
yes, my lord.
When?
After 26.
29th, 29/8,
Yes.
2020. Yes. Oh, but what are we?
Highly obliged.
Miss U Sharma shall produce the contiguous records, contemporaneous records of, including the records wherein the bills of the petitioner were processed for payment shall be placed before this court without fail. You have got the records.
Well, I have got the records, I have received, four files, 4 office files.
Huh.
And,
Have you gone through it?
I have seen.
What is the
I've
position?
taken note of.
What is the position? Why is the bills not being cleared?
Well, in fact, before I take your lordship to the records, I'll take your lordship to the affidavit filed by the respondent. But there is an affidavit filed on 3/2/2016, by respondent number 1, 2, and 4.
146.
My lord, this affidavit has been withdrawn, my lord. White order dated, my lord.
146. Order dated?
Order dated 19/1/2016.
19/1/2016, we withdrawn the earlier affidavit. Thereafter, this affidavit on 3/2/2016 was filed. I'm referring to the 3/2/2016 affidavit.
It was filed on 4/2/2016.
Lordship.
3/2, but it was filed. Huh? Some earlier affidavit was filed, withdrawn.
It was filed in it was filed earlier, Lord. That we have withdrawn. There is an order of 19/1/2016.
Okay, fine. Proceed. Biren Chandra Phukon, yes.
Well, Biren Chandra Phukon. Well, here, I'll take your lordship too. Well, in fact, my submission would be, Lord, that there is, the amount is not admitted and there is dispute, Lord.
Okay, we are only trying to find out whether that dispute is a created one or
No.
a German one from the records.
Lord,
Because what I have
Lordship.
understood is
Lordship.
that he had to telecast 12 commercials.
Lordship.
He telecasted 6 commercials.
Lordship.
The director or the producer of those balance 6 had given a letter that these are with me. I can hand it over. But there is nothing on record to show that you had taken it over and given it to him.
But what I have seen from the affidavit, Lord, lordship kindly comes to paragraph 3, Lord. para 3. Matlab 2, I will also praise as regard maintainability, but now matlab I will take your lordship to para 3, my lord. But issues involved in the writ petition is of a civil nature which involves monetary liability arising.
No, I
out of
got
an
it. You
agreement.
just give me that, clarify that aspect, that
Yes, yes.
12 commercials were given to him.
The petitioner has not submitted a clear picture as regard the total bill amount along with the total number of telecast details.
Okay, you come to para 4.
Lordship, the petitioner has failed to submit actual number of telecasts along with the details of bills as received from the various TV channels of by the petitioner. Therefore, the question of payment of alleged outstanding bill amount of
Fine,
rupees
we
53
accept
lakhs.
that, we accept that.
Lordship.
Come to para 4.
Yes, my lord. It is most respectfully submitted that by the respondents that the government has sanctioned an amount of rupees 382.13 for telecast of 12 TV commercial produced by so and so, but the petitioner had telecasted only 6 number of TV commercials, causing loss of public money, and the purpose of campaign was not fulfilled. The respondents were not
Okay,
able.
now just show me,
Lordship.
when was this 6 was given to him, he also admits. We'll
Yes,
go by the reverse thing.
6 he has received.
Show me when the next 6 was given to him.
Well, telecast is not there.
Where is the letter of that producer? Mr. Janu Burwa is on record somewhere.
Yes.
Just show me that. Just find that out.
Yes. And
So your case is 12 were not. Show me
Not-
from your records that
not-
all the 12 spots were given to him.
But the paragraph 8, paragraph 9, paragraph 8, my lord, we have given a reconciliation statement. Now in
I'm on the question. I'm on the other question because everything boils down to that, whether he was given 12. Your all other pertains to that he had not telecast 12. He had telecast 6. So the bills that he has raised will not be
for 12.
12. So it can only be construed for 6. So now you show me that he says contrary, that 6 spots were given to me, and on the dates which were mentioned, I had telecasted all this 6 in the slots, and my bills correspond to that. He has also brought the bills of the telecaster, NDTV and all others.
We said in the affidavit, we said that the telecast from the channels, whatever bill he has given, those are not telling with the bills. We have in affidavit, we have said.
That is again 12. 6.
No.
12.
The telecast bill. The channels, the channels were mentioned in a particular clause of the agreement. Those channels, they have raised.
Okay,
the bills.
you proceed. Then what happens?
Lordship. Lord, if kindly allows me to read some of the paragraphs of the affidavit, then it will be clear. Paragraph 8.
Okay, you can come to para 9. I've read it. You can come to para 9.
Yes. The amount and interest and its interest thereon as claimed by the writ petitioner is nothing but an afterthought and a pre-plan for the genuine gaining undue advantage. The outstanding amount as claimed by the writ petitioner as per annexure B of the writ petition is rupees 63 lakhs and interest thereon has no basis at all, as the writ petitioner has neither submitted any audiovisual clippings of the said advertisement nor submitted any original copies of bills as submitted by various TV channels to the writ petitioner. Therefore, the amount as claimed by the writ petitioner is unjustified. Then next paragraph, my lord, that it is most respectfully submitted by the respondent that as mentioned in the statement of accounts, as submitted by the writ petitioner is for rupees 3,22,66,668. But the said writ petitioner has submitted the bill for rupees 2,68,87,216, and the bill amount of rupees 53,79,472 has yet not been furnished by the writ petitioner. Well, the copies of statement of bill received from the petitioner, statement of bill not received as per the statement of account submitted by the petitioner we have annexed.
And the reply is there.
In the reply, my lord, now everything has come. My lord, he has given so many documents, my lord, my respectful submission would be, my lord, these documents, my lord, in fact, in reply, they said that all evidences we have placed before the honorable court. My lord, evidences in my respectful submission are to be examined and the authenticity has to be tasted in a suit, my lord, not in the writ petition, my lord. My lord, paragraph 11.
that it is more respectfully submitted that the respondents that the writ petitioner has submitted an exorbitant amount of bills in comparison with the bills amount as submitted by various TV channels for rupees 38 lakhs 80,453. That is the bills submitted by the TV channels. Next paragraph, my lord, that it is submitted that the respondents that the reconciliation statement as prepared on the basis of the statements of accounts submitted by the writ petitioner, it is found that inadvertently an amount of rupees 27 lakhs 59,000 has been paid access to the writ petitioner. Therefore, the question of payment of alleged outstanding bill amount of rupees 63 lakhs 9,596 does not arise at all. Rather, the respondent is receivable of rupees 27 lakhs 59,000 as per reconciliation statement. So, in my responsible submission, there is dispute. There is the facts are disputed. The documents are also the claim made by the petitioner is also not admitted. So, in fact, in the writ petition, if lordships now lordship may kindly
My lord was
come
making
to
a
the reply.
query
Where is that?
at page 20, my lord, 120, my lord.
Of the,
120 serially, my lord. That is my affidavit, my lord, additional affidavit. Wherein, as for record, I have put it on record, my lord. Record will reveal that. 120, my lord. Paragraph 5, kindly see. The petitioner states that the plea has been taken that the respondent 6 TV commercial has been shown in place of 12 commercials. The aforesaid plea has no legs to stand in view of the following based on record. There is absolutely nothing to show that 12 commercials were handed over to the petitioner for telecasting. Annexure A and Annexure B of the affidavit in reply clearly shows that 6 TV commercials was provided for the purpose of telecasting. The document marked as 118C in the record, my lord, which is letter written by one Sri Jahanu Borua to the Director Tourism stating about running of 6 TV commercial for 4 months. My period was 4 months. The contents of the aforesaid letter is marked here in below. This is the contents. And this is after perusal of the, my lord will kindly see at page 121 also. What was the FAO remark? Financial and Account Officer. A, B, and thereafter. In this regard, it may be stated as for agreement signed with Group M, the first installment 20% was already paid. Aforesaid firm has successfully completed the work as per agreement within 4 months, commencing from September 2011 to December 2011, and submitted necessary bills along with telecast certificates and amount spent accordingly. The name of the channels, duration of telecast, time, etc. also been specifically in every telecast certificate. As per assessment of telecast certificate and amount given till
yes,
date,
Mr. Nath,
amount is so and so so and so.
your that plea, have you made a reply to this additional affidavit brought on record? Because this additional affidavit was filed by him.
Affidavit in reply.
No, this page 118. Additional affidavit after he had perused the records.
Yes.
After the records were perused, these
Sure.
things have come on record.
Sure.
So is this reply of yours to that reply? 146 is to that? I don't think so.
From the affidavit in reply,
Okay, fine. Got it.
affidavit in reply of the petitioner, I'll take your lordship to paragraph 10 and 11 of their reply.
Affidavit in reply.
10 and 11 of their reply. Reply affidavit.
Hmm.
What my lord, they would like to say in the reply, my lord.
Please.
Lordship. With regard to the statements, my lord, has lordship got, my lord.
Hmm.
But with regard to the statements made in paragraph 8 of the additional affidavit, the answering petitioner states that on 6/9/2011, they paid an amount of rupees 75 lakhs 67,562. Further, an amount of rupees 1 crore 78 lakhs 70,388 was only paid to the petitioner on 6/4/2012. If the aforesaid two amounts are added, then it amounts to 3 crore 54 lakhs
2 crores 54.
2 crore 54 lakhs 37,950, The answering petitioner state that Annexure 2 is an incorrect document in view of the fact that Annexure 2, which consists of 2 pages, show that the petitioner company is entitled to 2 crore 68 lakhs. Look, now the Annexure 2 in the affidavit in opposition, the additional affidavit we filed, he disputes that it is an incorrect document.
He disputes because the amount there is more. He claims a lower amount.
Absolutely.
Logic.
So to that extent, he
Logic,
says it's a calculation error,
logic.
right?
The aforesaid facts reveals that rupees 14 lakhs 49,265 only has been due to the petitioner from their own documents as per Annexure 2. The answering petitioner further state that the reconciliation statement is annexed as Annexure 1, wherein it reflects that Annexure 4 is an incorrect document in view of the fact that the Annexure 4, some of the bill amounts of channels are not reflected. Next parabola that the petitioner states, so far it relates to paragraph 8 of the additional affidavit. The answering petitioner categorically states and are producing documentary evidence to show that some of the bills raised by the respective channels have not been taken into consideration. But all the bills running into 100 pages, more than 100 pages are annexed here.
Mr. Have you given to the government when you submitted your bills, the original bills from the?
Bills by the TV channels
Channels.
and the telecast certificates also.
And they have reconciled as per my affidavit. Reconciliation statement has been prepared, and now all the bills have come along, and the documentary evidence to show that some of the bills raised by the respective channels have not been taken into consideration by the respondents. The answering petitioner categorically states that in item number 1, 18, 23, 25, 67, and 69, wherein it states that item number 1, bill number 80024/2011, dated 10/12/2011, the petitioner raised bill of rupees 2,27,094 only, whereas respective channel raised.
Okay, Mr.
For-
Nath, I've got it.
My
As per your thing, if I have understood correctly, one, he had not telecast 12. He had
No.
telecast 6.
6.
2, he had not given the originals.
The bills, all
In-
yes,
Bills, not all bills, not in original.
from the TV channels, the bills given from the TV channels who have telecasted, they have submitted some bills.
That was not forwarded to you.
He has-
He had forwarded something else,
No, he has
copies.
He has submitted some bills, but that and the claim made by him and the bill submitted by him
Does not match.
does not match.
3, you say that 1 is this, 2 is this, 3. The video clippings of the telecasts made
Not
were
provided.
not given.
Not
Let's go back to the these are the 3 issues you have.
These are the 3 issues, and now, in fact, I have indicated that in fact some excess payment has been made according to that.
That's a reconciliation
Logic.
statement. Now let's
Logic.
come to the straight to the agreement.
Logic.
Where is it? Mr. Bhuya, where is your agreement?
At
That
page
might-
23,
Yes.
page 23.
Yeah, I got it.
Page 23, my lord.
So the conditions would be at page 24.
Yes.
Page 24. Page 24. Page 24.
Page 24, my lord. The budget is in paragraph 1 itself, my lord, 3 crore 78 lakhs.
Hmm.
And for the first phase of campaign spanning
months.
4 months,
Hmm.
that is there, my lord. And the name of the TV channels are there. That is number 2, my lord, clause 2 of the agreement. The second party shall complete the execution of first phase of the campaign spanning for a period of 4 months. The first party shall make the payment of so and so, so and so, so and so in 3 installments.
So if you come to clause 7,
Yes.
the first party shall hand over the original creatives of the campaign made by
Okay.
so and so in DVD format to the second party along with the sequence to be followed for releasing to the TV channels. So the sequence as well as the content is given by the respondents.
Yes. And what is the telecast plan, my lord, timing and
That is
everything?
also been given.
Yes, that's been already all along
Okay,
given. my lord, we approve
now
that
the
telecast.
thing is, that is not proved, but 12, para 12 shall
para-
submit
para
original
eight-
copies of
Original
bills.
copies we have submitted.
Para 8 also, my lord. Para 8 also, my lord.
Shall return the, have you written this?
Original DVD, my lord, we have returned everything. First, we have received one.
So only thing we got to look into now is whether the clause 7 was fulfilled
Yes,
and whether the bills claim
yes.
also amounts claimed tally with the original bills given from the channels.
TV channels.
Yes,
That's all.
that's all.
So give me a list. Both of you give list that these are the bills submitted
Yes.
from NDTV with the names there
My,
on so and so, so and so. So amount is this. This is the.
my lord, that's been from the record. The note sheet happens to be the.
Find that out for me.
Yes, let the record be given. I show from the FAO. FAO have verified and
It's
saying
verified.
everything is honored. Clear the bills. Can you give me the records?
No, fine. We'll give you. the
And
record.
I have put it on record, my lord.
Mr. Nath, you go through the records. His contention, there is a specific statement also.
Yes.
He has filed an additional affidavit because this court permitted him to go through the records, it seems. And thereafter he said, now only two things you have to show me. That is para 7 and para 12.
12.
If this thing, both things you show that yes, the 12 spots were given to him. So naturally for not telecasting the 6 DVDs, he'll not be entitled to any money. So that part gone. Second, the original copies of the bill received. Find out if the note sheets, he says some FAO has gone it
Yes.
at that point of time. Go through it and then see thereafter whether there was any dispute raised to that FAO's conclusions. Because if an authority of yours have gone through it and have come to a conclusion, everything is here, subsequently the bills can be misplaced.
There are
That will not take away the conclusion you have reached.
But from the affidavit, what I could ascertain that the TV channels bill they have said it is 38 lakh something,
Hmm.
and which is not telling with the bills submitted by.
So
the
you go to that FAO's report,
I'll-
FAO's
I'll see.
thing, that is
Whether
an
the-
additional affidavit.
21/3/2012. That will reveal my lord.
Yes,
That additional affidavit with Mr.
Yes.
Bhuiyan just
they
read.
have referred to the file number.
23/3/2015.
So you go through that
Yes, that will be the.
and then that would be the end of the matter.
End
If
of
you
the
can
matter.
show me that, see, even in spite of this plea that was taken in the affidavit is correct. We'll ask Mr. Bhuiyan to go to the civil court.
Yes, my lord. It will be this.
And
one-
also that 12 spots,
Yes, yes.
7 and 12.
And
Para
one
7
point, my lord, they have raised with regard to this, that DVD has to be given. That's not part of the record, agreement. But even then, we have right to the channels. And channel says, as per this law, my lord, can you see this law? This is a 5th December 2011 Government of India's guidelines, 5.12 clause. So, my lord, as per 5.12 clause, that is applicable to electronic medias, my lord. That preservation has to be, they have to preserve, the channel has to preserve it for 90 days. And thereafter, even the court directs it, they cannot, my lord. They destroys it, my lord. And this is the clause.
No, here destruction is not there. They say that they'll keep it for 90 days.
No, my lord, this is the Government of India's guidelines. So they have to keep. It's been a mandatory. They have to keep. But if a request has been made after 90 days, they cannot provide it, my lord. And with regard to electronic media, my lord, cable TV regulations of 1996 is applicable, my lord.
So
And
when can you give me this details?
Well,
if the record is being given to me, I can flag it, my lord, my portion.
both of us can have a look at now. Well, I'll just well, with apology, Lordship, may kindly indicate the two issues, Lordship has ultimately.
No, I'm considering the matter. This
True.
is something which I require a clarification.
True.
So with regard to clause 7,
Yes.
Yes.
page 23. Mr. Hutt, Mr.
In fact, my lord, if paragraph 6 of the affidavit in reply, if Lordship comes
I'll come to, we'll first go by step.
Yes.
Why should I go by the secondary evidence when I have the first primary thing before me?
Absolutely.
Mr. Dina, senior government advocate appearing for the respondents, has made his submissions in the matter. Also, in course of the submission so made, a query is raised by this court pertaining to clause 7 and clause 12 of the agreement entered into by the government of Assam, by the Director of Tourism, Government of Assam, with the petitioner firm. Also, clause 7 requires that the petitioner is to ensure a petitioner is to be provided with the original creatives of the campaign in DVD format, along with the sequence to be followed for releasing to TV channels. So, in terms of the agreement, in terms of the pleadings brought on record, it is the stand of the respondents that the petitioner was required to telecast 12 such creatives, whereas only 6 were so telecast. Per contra, it is the stand of the petitioner that only 6 creatives were so furnished to him within the period of the campaign, that is, for within the 4 months after execution of the agreement in question. Mr. Nath shall clarify as to whether 6 original creatives along with DVD of the same or 12 original creatives along with DVD of the same were handed over to the petitioner in terms of clause 7 of the agreement. Mr. Nath further submits that the provisions of clause 12, this court further requires Mr. Nath to examine, to bring on record materials to establish that the petitioner herein had not submitted the original copies of the bills received from the TV channels on completion of the campaign. Also, it is the contention of Mr. Nath that the records reveal, and also as disclosed in the affidavits filed by the respondents, the bills from the TV channels as submitted by the petitioner does not add up to the total amount claimed by the petitioner in the present proceedings and or in the bill submitted before the authorities.
Para 11.
Authorities. Also, per contra, Mr. Mia submits that the original bills in question were submitted and the same from the records, and the same would be evident from a perusal of the records, wherein the bills of the petitioner on being examined in relation to the original copies of the bills from the TV channel submitted, the total amount now claimed by the petitioner was decided to be released to him. So Mr. Nath would examine the records and apprise this court about the veracity of such contention made by Mr. Huyan. Mr. Nath shall also examine the records and place before this court as to whether subsequent to the said decision being arrived at, there were any further decision reviewing such decision arrived at, and if so, the materials basing on which such a decision was subsequently arrived at. Also, the above instructions we place before this court on. I'm not here till 30th.
Yeah,
Let us have it on 5th is a Thursday. I fixed one matter. We'll have this up. Right? 13 matter. I'm not going to. List this as agreed to by the parties. List this matter again on 5/9/2024 for further hearing. It a move did what happened.
I'll place the records by flagging it or in the.
No, you go through it now.
Not
Finally, you give me. If you
Yes.
want,
Yes,
if
I
you
have
want
put it in my affidavit.
Mr. Bhuyan's affidavit, he has brought it on record. So he can just indicate also.
Yes.
Logical.
It's not adversarial. If a man is getting it, otherwise we'll ask him to go.
Absolutely.
No problem.
That is the thing.
Logical.
And we have quoted in the affidavit also after.
That's what I said.
Yes,
That's why.
true.
That will be on record now.
No, there might be some subsequent decision maybe.
Maybe,
We'll
but-
only want to have that.
Huh.
And Mr. Bhuyan, if we find that there is a disputed area,
That's a different issue.
Now, if these two issues are clarified, dispute will not be there.
Absolutely.
But even in spite of this, there is a dispute, we will not entertain.
That your lordship discretion, my lord. But by way of an affidavit, they cannot
No, that's
change
why I'm
the
going, I said,
goalpost all the
I
time.
don't want the secondary one, I'm going for the
Yes,
primary one. And let Mr. Nutt make his examination.
Lordship.
You have it.
Lordship.
Item 43.
Hey, Dutta was an outlet of dispute, isn't it?
Make legal lordship.
Hmm.
In this case, lordship notice was issued on 15/7/24.
Hmm.
No affidavit has been filed, my lord. Sorry, madam.
There is an interim order in your favor.
Interview in my favor. It may be allowed to continue.
Yes. What happened? No affidavit. Private respondent has also not appeared.
No private response is there.
Oh, you're only. Miss, you does learn additional senior government advocate praise that she be granted.
DC Mala, we are appearing the Fishery Department, Mr. P. Sharma appearing. So this.
None appear, heard Miss MSP. Bora, learned counsel for the petitioner.
Lordship,
Yes.
I will file affidavit, Lordship.
Also heard Mr. P. Sharma, learned standing counsel fishery department, who submits that he would be filing the affidavit in the matter on or before 28/8/2024. Registered to list this matter again on 30/8/2024. In the event the affidavit is not so filed, the court proceed to consider the issue arising in the present proceedings, basing on the materials available on. There is a stay order, you are losing out of revenue. Why are you?
Losing revenue, Lordship.
You're not losing.
Not losing revenue, because we are already, we are getting revenue. Actually, well, they are paying Lordship now.
They're paying.
My lord, interim order will be continued.
Interim order passed earlier to continue till the next date of this. File the affidavit by 28th.
Once over.
Next Friday.
That's all.
Lordship, in this case, the government has filed an affidavit. I need a short time to file my reply. Can it be taken up next Friday?
Mr. M. Das, learned counsel for the petitioner submits that he requires. Next Friday,
Next Friday, Lordship.
Friday is a holiday. Prays that he be granted a week's time to bring on record his rejoinder to such affidavit filed by the respondents. So, the
Lordship,
affidavit
will
filed by the
30th?
respondents is not available on record.
30th is
Post op.
open day.
The registry to trace and tag the said affidavit along with the records of this case on the next date of listing. So, petitioner may file his rejoinder on or before the next date of listing. Registry to list this matters again on 11/9/2024.
All right.
As per the last order, Lordship, today is fixed for the issue regarding consideration for whether the respondent it can continue to live against beyond the month of August 2024. Service upon the private response completed, Lordship, we have filed last year it's also. What happened, Lordship, in this case, Lordship, pursuant to this honorable court order, a speaking order was passed in mechanical manner, Lordship, on the pretext that
Have you brought your record on your record the
My
stand?
lord, I am appearing for the private respondent number 8 on the last occasion we have entered appearance, my lord. My lord, I'm only praying today, my lord, we have to bring certain things on record. And we have to file our affidavit, my lord, which I didn't get the occasion to file, my lord. So I'm just praying for 10 days time. And moreover, my lord, the prayer which my learned friend has made, my lord, he has not revealed the entire picture, my lord, because.
Okay, fine, you reveal.
Yes, my lord.
Why, that is why you are being made a party.
Yes, my lord. So the prayer maybe he is making for interim order today. So I have.
I'll defer that for a week, no problem.
Yes, my lord.
Then we'll hear.
I pray for Mala 2 weeks time.
Why, what is the point? You have been given time from 23/7. Why affidavits are not being filed?
already July month they have lifted.
Maybe.
Already July.
As prayed for by the learned counsel for the parties. The learned counsel for the respondents submit that they be granted further 2 weeks time to bring on record their stand. The respondent, the Karnataka Council for the respondents undertake that before the next date of listing, affidavits on their part would be brought on record. Accordingly, list this matter again on 6/9/2024. Full stop. In the event the affidavits on behalf of the respondents are not brought on record, this court would proceed to consider the issue arising. Consider
Six and ten.
consider the interim prayer so made in the present proceedings, basing on the materials already available.
I'm highly obliged, my lord.
Yes, yes, your lordship. Lordship, can it be taken after some time?
Today may not be possible. Yes, where is Mr. Gogoi? Has he got his instructions? Get hold of Mr. Gogoi. Yes, where is Mr. Naik? How far have you constructed? You are for the petition, how, the building construction, 7th floor or beyond 7th floor?
The permission is Lordship G+7. In the NOC, it is stated lower ground floor and upper ground floor. Lordship. So Lordship, 2 ground floor and 7, it's 9. But Lordship, in the construction, they have not constructed lower ground floor. Lower ground floor, Lordship, that is below the entrance. Below the entrance of the building, Lordship.
Down, underground.
Basement, Lordship.
That is for parking.
They have not constructed basement, Lordship. Just ground floor and above 8 is 9. Lordship.
Get hold of Mr. Naik. He was supposed to receive instructions.
Not pertains to high voltage transmission line.
Have you incorporated?
Yes, sir. On last witness.
Where is Mr. Sahewala? Oh,
Lordship, he is on legs, lordship.
okay, fine. We'll record his name.
Hello,
You appear before the deputy commissioner. Sorry, district judge. File an application before the district judge. You're disposing it.
Also, my lord, your lordship was pleased to dispose of a matter. My lord. Last witness day.
Similar matter.
Yes, my lord, in terms of this.
Nothing has been shown on already.
We'll record his name for power grid.
Not shown, it's not. It is shown, that is why we are appearing. I think. That's okay. We don't need showing on him, they cannot be disputed.
My lord,
Dispose of.
only my prayer is, my lord, in earlier petition, my lord, the direction was within 30 days. My lord, can you give 45 days? There are numbers of petition. 45 days.
45 days.
Yes. Oblige me. Your lordship, on the last occasion, your lordship had directed me to produce it.
That order.
Yes, your lordship.
In the complaint file, it was that the case was not registered
Yes, sir.
because it was registered thereafter.
Yes, sir.
Okay. But Mr. T. Dury, Learned Counsel for the petitioner, and also Ms. Udas, Learned Additional Senior Government Advocate, appearing for the respondents. None has entered appearance on behalf of the respondent number 1. Udas, respondent number 2. None has entered appearance on behalf of the respondent number 1 and 3. No private respondent has not come here.
Oh,
3. So, hearing concluded, list this matter again on 9/9/2024 for delivery of orders. We'll expense that part.
I don't know. In the morning, I have received the affidavit filed by the respondent. I need some time to go through it, Lordship, and to file rejoinder if necessary.
I filed the affidavit as per Lordship, order dated 14/9/2022.
Mr. G.R.A. Motak, Learned Counsel for the petition, submits that an affidavit on behalf of the respondents has been received by him today. Accordingly, he prays that the matter be taken up after 2 weeks, enabling him to receive instructions thereon. And if so advised, if so required, to file and rejoinder. Was a prayer accepted? Prayer is not objected to by the Learned Counsel for the respondents. Prayer accepted. Registered to list those matters after 3 weeks on a date to be fixed by it.
Much.
Yes, what is your instruction?
Instruction, they were not aware about this. That is the instruction, and as per document, you know, I leave it to your lordship to.
Nothing, you tell me. If we go in, it will be different. You tell me.
My only ground is that that alternate land was offered after LOI.
It is provided.
That was not to communicated to.
And I required you something from your end also. Para 15. Para?
13, Your Lordship.
That is 9. That is only the grievance.
That the petitioner begs to state that the guideline for selection of retail outlet dealership does not provide for alteration of land except in case of non-suitability of
Mr.
land
K.M. Halai.
offered by all applicants of group.
Fine. Heard Mr. K.M. Halai, Learned Counsel for the petition, also heard Mr. S.S. Roy. Oh, you are appearing from, on behalf of S.S. Roy, or you will be there?
I'm there.
On behalf of respondent number 2, 3, and 4, and also heard Mr. M. Sharma, Learned Counsel for the respondent number 5. The challenge in the present proceedings is to the selection and appointment of the respondent number 5 as a retail outlet dealer of HPCL at Solbok Town, District Borkata, in pursuance to an advertisement issued on 25/11/2018 in this connection. So the petitioner in the present proceedings has raised a grievance with regard to such selection and appointment of the respondent number 5 as a retail outlet dealer on the ground that the original land that was offered by the petitioner and against which his such selection was so done, having been placed in group 1 of the various categories so delineated in the advertisement, in the guidelines, was changed by the petitioner after the letter of allotment was so issued to him. So, the respondents herein have, it is the further case of the petitioner that such change of the land initially offered cannot be sustained, and accordingly, the letter of appointment of the petitioner as a retail outlet operator under HPCL is required to be interfered with by this court. That's your case. So the learned counsel for the respondents number 1 to 4 submits basing on the policy, on the guidelines involved that the selected entity is permissible, it is permissible for the selected entity to offer alternative land if the situation so mandates. Also, in the present case, it is submitted that after the petitioner was so selected, after the respondent number 5 was so selected for being appointed as a retail outlet dealer for the products of the respondent company, comma, the land as initially given by the petitioner was initially relied by the petitioners was required to be changed for reasons beyond his control, and accordingly, in terms of the policy itself, which permits such offering of alternative land even after the selection of the entity, selection of the retail outlet dealer is made and a letter of appointment is so offered to him. Also, in this connection, reference is made to note 3 of the guidelines available on page 22.
Yes, internal page 9. Yes, page 22.
So the above provision being of relevance is quoted here in below. Note A to A, page 22. Also, it is further seen from the record. Also, the learned counsel for the respondent number 5 has also endorsed the submissions made by the learned counsel for the respondent number 1 to 4. Also, the issue arising in the present proceeding is as to whether after issuance of a LO letter of acceptance to a selected retail outlet dealer, selected to an entity selected for being appointed as a retail outlet leader, it was permissible for such dealer to offer an alternative land by ignoring the land already offered and basing on which his empanelment and selection was so undertaken. Also, the said position is clear from the guidelines or guidelines holding the field in this connection, wherein under note 3 bracketed quoted here in above, it is said that such offering of alternative land is permissible, subject to the alternative land so made offered meeting all specification, and it is within the advertised location / stretch. So it is not in dispute it is not disputed by the petitioner hearing that the alternative land offered by the petitioner does not meet the specifications as mandated to be so satisfied. Does not dispute that the alternative land offered by the respondent number 5 does not meet the specifications so mandated to be satisfied, and also it is not disputed that the alternative land so offered is beyond the advertised locations / stretch. Also, the materials brought on record also reveals that the district of revenue of the district authorities of Borpeta had also accorded its approval to the setting up of the said retail outlet of the responding company over the alternative plot of land as offered by the petitioner hearing. It is also to be noted that after the alternative plot of land was found to satisfy the specifications so made in this connection, an addendum to the letter of appointment as issued to the petitioner was also so issued. And what is the status today?
We have been operating since February.
And the respondent number 5 on completion of the construction activities involved, and also after getting the requisite permissions, is operating the said retail outlet with effect from
February 2022.
February 2022. So in view of the above position and in absence of any material brought on record by the petitioner of there being a violation of the guidelines involved in this matter, This court is of the considered view that the contentions raised by the petitioner in the present proceedings does not mandate acceptance, and accordingly, the writ petition is held to be devoid of merit, and consequently the same stands dismissed. However, there would be no order as to proceed. Next time, better.
Well,
Lordship, may I please, your Lordship? Lordship, in this case, in item number 66 and item number 70, we were supposed to file our affidavits. The affidavits are ready, Lordship, and we'll be filing it by next week.
On the prayer of Mr. D. Panel Learned Counsel for the petitioner, or for the respondent. List this matters again after 2 weeks. In the meantime, the respondent shall invariably bring on record their stand by way of filing an affidavit. Registered to list this matters after 2 weeks on a date to be fixed. This matters will take time. We'll fix it. You make a mention after 2 weeks. We are here. We'll accommodate you. No. One six. Your name?
D Pathak.
D. Pathak, Learned Counsel for the petitioner. Also heard Mr. T.R. Gugoi, Learned Standing Counsel, Assam State Housing Board. The grievance raised in the present proceedings by the petitioner pertains to the deprivation. Pertains to the deprivation meted out to him in not allotting to him a suitable flat by the respondent, Assam State Housing Board, in spite of submission of a due submission of application complete in all respects. Also, it is the case of the petitioner hearing that in the month of March 2007, he had first applied for allotment of a flat /tenement, TENEMENT, from the respondent board. So, however, no such allotment came to be made in his favor till 2012. And accordingly, on 1/12/2012, he submitted a fresh application. So, during the pendency of the said application, it is submitted that the allotments of the flats as were available at that relevant point of time were completed, and the petitioner herein was again asked to submit a fresh application. So, although the petitioner in the writ petition has named certain persons who were favored with such allotment, in spite of the fact that they had applied after the date of application made by the petitioner in the matter, the petitioner has in therein claimed no relief against such persons. So, the respondents hearing have filed a affidavit, and therein has contended that in terms of the directions passed by this court-wide order dated 11/6/2018 in WPC number 2479/2018, requiring the board to formulate a policy guideline for allotment of flats as available under it, the board had on 3/8/2022 formulated a guideline for allotment of flat under rental housing scheme. Also, in terms of the provisions of the said guideline now brought into operation in terms of the directions of this court, wide the said wide the notice dated 3/8/2020, all old pending application forms for allotment of flats under rental housing scheme shall not be taken into consideration, and interested applicants shall have to apply afresh as and when the advertisement notices are issued. Also, the said guidelines also prescribes that allotment of the flats from amongst the applications received shall be so made by drawal of lots by the Commissioner, Assam State Housing Board, or any other officer authorized by him on his behalf. which draw of lots shall be done separately for different category of flats under the rental housing scheme. Also, in view of the above position, and admittedly, the application submitted by the petitioner in the matter having lost its force in view of the guidelines so framed, in pursuance to directions passed by this court, in the present proceedings, this court is not in a position to direct the respondent board to allot a flat, suitable flat to the petitioner herein. Also, in view of the said position and also considering the guidelines now brought on record, regulating the manner in which allotment of flats would be so done by the respondent number board, the petitioner herein is directed to submit an application before the respondent number 2 with all in the proper format with all requisite particulars, staking a claim for being allotted such flat. Also, as and when flats become available under the respondent board and a move is on to allot the same, the application of the petitioner shall be given a due consideration strictly in accordance with the guidelines coming into force via the notice dated 3/8/2020. Also, it is provided that the petitioner shall be required to submit different applications if he is claiming flats under different rental housing schemes. Also, with the above observations and direction, the writ petition stands disposed of. The Learned Counsel for the petitioner, for the respondent has submitted on instructions that at present there exists no vacant flats available in as much as no new constructions are underway. Also, be that as it may. A copy of the communication dated 14/8/2024 as placed on record by the Learned Standing Council of the board, respondent board, is kept on record and marked as X.
It is in the Barbara district.
Barbara district. At the Learned Council for the parties, list this matter as agreed to by the parties, list this matter again after 3 weeks on a date to be fixed by the district. If you have no urgency, why should we be there? You continue. They are also happy.
Look.
Be happy, both of you.
Lots.
Right?
Look.
You had expressed a lot of urgency in your speaking order. Shift it immediately. If you don't want to shift it, it's your policy. Why should we come in?
As per my instructions, in Sira, one temporary establishment is there.
What to do if the government does not want to shift? What we will do? We were ready today. But Mr. Goswami says he is happy with Borpeta. So let him be happy. You take it with the government. There is no interim order. Get it shifted. Until that time, the petitioner is also happy. So all happy. The court also happy.
Matter may be disposed of also.
Why?
We will give the.
No. I want the material. I want this thing done.
Actually, later on, all works has been done. We'll give the fund. We'll give the money whenever budgetary allocation is.
Oh, no, you give me a specific date. Why should I put a citizen to hanging that you will pay when you have? You have taken work. Tell me 1 month, 2 months. I will pass orders. Get your instructions. I'm here only till 4:45.
What you mean in that case?
No, today.
I have to get written instructions.
No, you get your oral instructions. We believe Mr. P. Sharma. But I want the authority who has given you the instruction. Give it to me, I'll dispose of the matter. Otherwise, I'm not going to just pass orders like that. Sorry. Get it? Oh, when? 21st. 3 p.m. On the prayer of Mr. P. Sharma, list this matters again on 21. On 21, reiterate this prayer.
For written instruction.
21/8 to date 24, on which date Mr. Sharma shall place before this court written instructions received as to the date by which the dues of the petitioner, which Mr. Mr. Sharma contends to be admitted, shall be so released to the petitioner.
Deeply obliged, highly obliged.
Yes, where is Madam Burwa? This is totally some other case.
Yes, Lordship, some mistake has been done.
Where is
by
the corrected one?
officers, Lordship. In this, in his case, that is 375017, FR was submitted already.
Submitted?
Yes, Lordship.
Give me that details.
I
You
have
send
received-
it to Madam.
Lordship, I have received it on WhatsApp, Lordship.
Okay, fine. You send it to Madam. She'll take out a copy for me.
It's a WhatsApp message, Lordship.
What
I
is
have
the
received on WhatsApp message. Screenshot may be sent.
FR has been sent.
Yes, FR number.
You show Mr. Polita. We have two matters waiting. We'll just fill.
In other matter, also, just now I have received the instruction.
Okay,
I
you
will,
give
send-
it to, give it to. We'll take it up after some time.
Yes. In this matter, just now I have received the instruction on.
Madam,
the-
you be relaxed. You show him before I rise,
No,
come
no,
back.
in this 26, item
Ah,
number 26.
26, okay.
Yes,
What is it?
here also instruction I received just now.
What is it? Okay, so go
I,
through it.
I will send it.
No, you go through it and tell me.
Yes, yes. Lordship.
Mr. Dhar, wait for some time.
Yes.
Yes, what is this? What is the claim? Give me that claim. 2015 onwards, what is the amount? What are the consignments involved?
Madam, kindly, madam, I have missed the case today, madam, kindly taken out. Kindly taken.
2015 onwards, you don't want money. You are allowing Mr. Goel to enjoy. Mr. Goel only has 1 point. Give me the details, then I'll able to rightly so. You say 2015 onwards, so much amount is pending, pay. Will anybody pay?
Madam, kindly taken on next Tuesday, madam, not this
On the
Tuesday.
prayer of Ms. A. Gayan, Learned Counsel for the petition, for the respondents, Railways, who submits that she would, without fail, place on record the breakup of the claim so made against the petitioner herein, why the notices impugned in the present proceedings on the next date of listing. List this matter again on 9/9/2024.
Nine.
Mention in Malur, they can't after delivery of.
Oh, first, let us know what it is.
Nine
That is the
September.
anxiety of this court. What is that big thing you have done? 15, they are making a claim today. I want to know what is that.
Madam, 9 September, madam.
9 September.
Must have been.
Mr. Barbuya is not there.
Number 14, I think.
Okay, ask him. We have disposed of the matter.
Lordship, only for today.
We have got the
Otherwise,
instruction. Finish.
As a last item, Lordship.
Okay, last time.
Much.
Last time. Yes. Yes, Mr. Barua. What is the instruction?
Okay. In fact, there was a meeting held on 14th
Hmm.
regarding the pending all the liabilities of the government lordship.
Hmm.
Actually, lordship, because of the non-availability of the fund.
Hmm.
So
What
they
is the fund availability required here? This fund is granted by the central government. You only have to make a bill there. They will clear the amount.
on the on that meeting, lordship, on 14th of August, lordship, the decision was taken to send a proposal for SD, lordship, supplementary demand proposal to the finance department.
I told you, give me a time limit. I only want a time limit. You're not disputing the claim. Time limit when you're releasing it.
Now, on 14, they have, that meeting was.
No, I
convened,
I'm
lordship.
looking, I don't look into the past. I look into the future. When are you paying that amount? That much only I want. 1 month, 2 months, that much only. Mr. Saraf will be satisfied. with
That time limit, lordship, because lordship, it depends upon the budget.
Is the finance department somebody else? Is it not within the fold of the state government?
Because in
Because you are
department-
processing the matter from 22. What were you doing? That's the details I want.
Lordship, because of
No, I'll put you in trouble. If I pass orders, if I want a breakup of what you were doing from 22. Next thing would be that, and the interest would be 9% from the date it is due. I'll pass that order. I'll give you time. How much time you want? I'll give you. 5 years, 6 years, 7 years, no problem. It is, well, ask Mr. Saraf that your claim is not disputed, so it's in the fixed deposit. You dispute the claim, I will be with you, but you have not disputed the claim. So why should a citizen suffer? His whole property. It's a constitutional right property now.
But may I suggest that you may direct them to payment within 1 month or something?
They'll not do that. You'll again come back.
They have to matter may be kept pending so that on that day, they will come. Otherwise, there will no pressure, they will not come.
Also,
Because Lordship, this issue has been, that's why that meeting was held, Lordship, because of the pending liabilities, Lordship. So very soon they will send a
They jump
proposal.
upon us. Let
you
me-
can't take the plea of financial constraint. You can't take that plea.
So if I have GST liability, they will wait, I will hold the meetings. They will attach my bank accounts.
And Lordship, chance may be given to file affidavit.
No.
Then Lordship.
No. We want the money. Paid the money because you have not disputed. Mr. S.R. Burwa, but Mr. A. Saraf, Learned Senior Counsel, assisted by Mr. A. Goel, Learned Counsel, appearing for the petitioners. Mr. S.R. Burwa, Learned Government Advocate, on instructions submitted that the bills of the petitioner hearing was forwarded to the government for approval by the
No, Lordship, it's instruction from the government itself, Lordship.
was forwarded by the government by the
No, by the SP, Lordship.
22 was forwarded by the Superintendent Police Border -1 Assam on 30/8/2022 to the government for approval. However, it is seen from the subsequent instruction produced from the government authorities, from the authorities of the Home and Political B Department, that the bills of the petitioner is still under process. Also, Mr. Burwa had received further instruction in the matter during the course, had further received instructions wherein it is said that a supplementary demand is being now forwarded to the finance
Will be forwarded.
will be forwarded to the finance department for sanction of the for the necessary funds to clear the pending liabilities of the petitioner hearing. Also, the bills of the petitioner has not been disputed by the petitioner, by the respondent authorities. However, the delay so occasioning in making the payments in spite of the fact that the bills were so forwarded way back on 30/8/2022 requires this court to direct the respondent authorities to clear the bills of the petitioner latest by 30/9/2024. Also, in the event they said bills are not so clear by 30/9/2024, this court would consider as to how the petitioner can be compensated for the delay occasioned in clearing his admitted dues. List this matter again on 1/10/2024.
Both the matters same.
Next.
I'm applying.
And what about this second matter also same?
Same one.
Yes, same also.
Heard Mr. So-and-so, so-and-so, so-and-so. इसमें खाली एक चीज करना, the bills as, when did you submit your bills, Mr. Saraf?
So this was submitted on
November sometime,
November 30th, 2022.
30 November 22. इसमें खाली लिखना, the bills of the petitioner hearing were submitted on 30/11/22 and the same was forwarded to the government in the Home and Political B Department for approval. So it is to be noted that the claim of the petitioner hearing is not disputed by the respondent authorities. However, Mr. Burwa on instructions have submitted that the bills are under process and would be cleared as and when the same procedure is completed. It is seen that for the last around 2 years, the bills have remained under processing. However, Mr. Burwa, basing on further instructions submitted, has contended that the Home and Political Department bracketed B department is approaching the Finance Department with an supplementary demand for budget, and on the receipt of such budget, the bills of the petitioner hearing would be so cleared. On receipt of the budget, you will clear the bills.
Yes, yes.
Also, considering the fact that the bills have been in arrears since the submission of the bills on 30/11/2022, and there being no material brought on record disputing the said bills submitted by the petitioner, it is directed. Oh, baki ek hi hoga again. September 30th, list again on 1.
I pray for a copy of this order.
We'll upload it today, tomorrow, latest. Download it.
I'm obliged.
Send it. Mr. Burwa, before this court dispute a bill, I'll not even touch it. If no dispute is there, then I'm not going to allow a citizen to suffer, whoever it is. It may be a 1,000 rupee bill, it may be 50 crores. Doesn't make any difference.
My lord, how many petitions are coming before lordship for payment of the bills? The rest of the bills are being paid.
Why? If you have taken a work from someone, how can you deny to him? Come up and say that this is disputed. Today, Mr. Bhuya's case, there is an area, gray area, which I wanted Mr. Nath to clarify. That's why I withheld my hand. I did not proceed that. Let Mr. Nath clarify. If we find it, we'll do it. But here in these cases, all the non-payment of bill cases that have come before me today, no dispute. The lowest was around 1 lakh something. That much also, that poor man, that may be a big amount for him. You're not clearing. You just sit in the AC office and just push the files. That cannot be. Dispute it that he has not done this work. File an affidavit. We are with you. Beyond that, Supreme Court has said, I have the power to direct you if there is no dispute. Please be a bit more upcoming in this matter.
Okay.
Yes, what is it?
Similar matter disposal was, disposal. Also in this matter, they were given 2 weeks time file the affidavit.
Yes, where is the affidavit?
Lordship, as far as I remember, Lordship, similar matter arising out of this NIT, Lordship, is being disposed of by coordinate bench, Lordship.
Where is the order?
I just forgot, Lordship.
Mr. P. Sharma submits that the issue arising in the present case is covered by a is covered by a decision of this court passed by a coordinate bench. So he submits that he will place the said decision on the next date of listing accordingly.
They have mentioned this case about this case earlier also. That is a different matter.
Different matter.
Different matter.
Just he is saying.
Yeah, they have.
He is just saying to buy time.
Lordship.
Yes, what is it? Why was it cancelled? Okay, we'll hear it.
Okay, hearing.
Mr. Shah, you have your seat. Yes, Mr. Sharma.
Lordship, they have, according to the order dated last order, they have participated in a new tender. And
that is without prejudice.
After that, now they are in the after the first and second bidder, they are in the highest bidder.
Now, in the second bidding process, you are also highest.
Yes, after the withdrawal of the first and second bidder, he is the highest bidder.
Then, Mr. Sharma, why is not being settled?
No, Lordship. Why, if he is the highest bidder, he will get, Lordship. No,
He has said, you don't know.
no, Lordship, it is earlier one.
There was
It is
time.
earlier one, in the new one, how can I?
No, that is because we have given him a liberty. If we have to go by the earlier one,
Lordship.
if he is getting the settlement in the second tender, why should we open this which you have cancelled? We will not look into it. You make the settlement with him.
No, Lordship.
If not, we'll have to examine this.
Lordship, listen to me, Lordship. Kindly, I may be allowed to. Lordship, here, what had happened in the earlier order, he has challenged this order, page number 26, Lordship. Page number 26, he has challenged. I think Lordship, if he is the highest bidder, Lordship, in the second bidder, in the second tender notice, which we have not annexed here, Lordship.
He
Sec-
cannot because it was after the order of this court, after he filed his writ petition.
Lordship, here, if it is so, Lordship, it will process from the DC has to, we have to, it has to come to us, Lordship. DC has to forward it to us.
When was the final bids opened?
Lordship, it was on 22nd of February.
February. Mr. Sharma, why this
If it is.
cat and mouse game?
They were given.
Why this cat and mouse game?
Lordship, no, Lordship.
As a standing counsel, you should be updated.
Lordship,
Why were you not given the instructions? Have you asked for the instructions?
Lordship, Lordship,
Yeah, because this order was passed by us on 22-1.
Lordship, let me, give me 5 minutes, Lordship, I will get.
5 minutes. Okay, 5 minutes.
Whether DC.
Kiman?
Lordship, we hear in this case, in last occasion, your Lordship has been directed to take instruction, your Lordship.
Change code, huh?
I have received one instruction that they have not preserved the file, so they seek adjournment for a week. That is the letter it is to me.
They
That
could
was I-
press out the file, letter you see, tally verified.
I quoted Lordship judgment order to the department. And contents, cramps, everything is there.
The account is still on, working? Is the account still existence?
Yes, yes.
Operative?
Yes,
Then?
The-
SBI, we'll ask the authorities to be here. How can the records be not there? If the account is operative? I can understand the account is closed, gone 5 years, 10 years, records are not there. The operative account, the records are not there. What is this bank?
That must I have got electricity status.
Okay, who is the man concerned? We'll call it
Branch manager, sir.
branch manager.
Ramapada State Bank.
Rangapara State Bank. He is actually a Lordship, he is a very newly joined. So the file has been since 2017-18. So let me for a week, that is their instruction they have said to me.
I can give you till maximum 21st. Beyond that, I can't. Or we'll have the man here to clarify. Because he is losing out on your fault. You will have to show that it is because of his fault that day. Because if you have changed that, that means KYC will deem that KYC documents were there. And the insurance coverage being lost, you will have to compensate.
Yeah, Lordship, I have given the contents and what Lordship has given, I have already messaged, sir.
So if they are not
I am the already.
reciprocating, you are not finding it very convenient with them.
Sir, Lordship, my.
We will step in. We will ask them.
Lordship, my only one point, because if Lordship permit me as a last answer, whatever the outcome it will be there. It will
No,
be-
Mr. It's not
Oh,
a
good.
question of outcome. It's a question of your conduct. If these are the pleas taken, what should we do? A operative account, you don't have the documents. What is that bank? A closed account, I would have understood. But Mr. Biswas says it's an operative account. And if it's an operative account, that file should be there. Because you have to verify signatures, everything. We'll have to think twice now before with SBI. If this is the conduct, if you don't have documents, what will we infer? Mr. B.N. Gogoi submits that. Mr. B.N. Gogoi, Learned Standing Counsel, SBI submits that the instructions required to be received by him in terms of the orders passed by this court, in terms of the directions passed by this court, while order dated 12/8/2024, could not be placed before this court as the file, relevant file, wherein the particulars of the documents of pertaining to the account of the petitioner is kept is not traceable. Mr. Biswas has made categorical statement that the account of the petitioner is operative. Is operative. I've recorded it. Mr. Swift is operative. If the account of the petitioner is operative, it is not understood how the corresponding file wherein the documents of the petitioner are kept is stated to be missing. This is not acceptable. Accordingly, however, considering the prayer made by Mr. B.N. Gogoi, Learned Counsel, appearing for the State Bank authorities, to afford him one more chance to produce the required instructions, this court fixes the matter on 22/8/2024. If by the said date, the instructions as sought for are not received by the Learned Counsel for the State Bank of India, this court would consider issuing directions requiring the presence, requiring the personal appearance of the concerned official to answer the queries of this court. No, no. 22nd,
26.
22. Mr. Mayor, go away, please impress upon them.
Deep level.
Yes, Mr. Bora. What is this? What is the instruction?
There is some miscommunication between myself and the P Nayak, my lord. I cannot get the instruction, my lord, whether the building is up to 7th floor or 9th floor, my lord. The building is given is ground floor or upper ground floor and 7th floor.
So he says that the upper ground floor is not created.
My lord, the NOC.
No, NOC is correct. The
NOC is there.
practical thing is he has not connected.
Lower ground floor, upper ground floor plus 7.
Hmm.
So it says it is 9th floor. But I will get the instruction, my lord.
One should be underground, lower ground floor.
Lower ground floor, upper ground floor.
Then the basement, what we know as basement, or the whatever you call it. Then
Plus
first floor,
seven.
second floor,
Plus
7th
seven.
floor.
Which
He
is it is
says
9th floor.
that the underground is not there, that underground has been transplanted as a floor, upper floor. How can it be?
I will get the instruction.
He wants to withdraw it, but this is coming to our notice. Why should we permit him to withdraw? We will pursue this matter. We are pursuing this matter.
I will get the instruction, my lord.
When?
After 10 days, my lord, I will get the instruction.
On the prayer of Mr. S. Bora, learned counsel for the petitioner. For the respondent GMC, registered to list this matter for further hearing on 3/9/2020. Ito pothai dibo. Timing ini check koi lo. What you?
I got the information.
Yes, what is it? Yes,
Yes,
Mr. Shah, what is your item?
Lordship, here the fact is that we got the proposal from Deputy Commissioner, Lordship, as per Rule 12 of our fishery rules. We have to act. Here, Lordship, validity of the Bakija certificate, we have given an inquiry to the DC to verify the validity of the Bakija certificate. And first bidder and second bidder has withdrawn the bid. First bidder, so we are not supposed to say, Lordship, because as per Rule 12, Lordship, DC only has to forward all the tender documents. We have to give our opinion. It is not that we have to give the valid highest bidder. It may not be. And again, Lordship, there is a suspicion in the neighborhood certificate of all the bidders. So we have put forward for an inquiry. Here, Lordship, if he considers, I don't know how he can.
No, forget it. We will now consider the earlier order.
No, Lordship, one thing, Lordship.
We are forgetting the second part. We will now consider the earlier order. Satisfy me. Why this is valid?
Lordship.
Why this order is valid? Satisfy me.
Lordship, why this order is valid, Lordship? Here in this part, Deputy Commissioner has to say, Lordship, this order is not valid. We are against this order, Lordship. Later part, Lordship.
So we are setting it aside.
No, Lordship. In this one part, Lordship. That one part, that Deputy Commissioner cannot put this part, Lordship, where the tender committee decided that call deposit of Sri Pramod Chandra Das will be forfeited and decided not to allow him to submit tender for the fishery. That part, Deputy Commissioner has.
What is this meaning? You have not submitted rates as per Rule 48(3), differential and arbitrary rates?
Lordship, the Rule 48 subsection 3 is no such rule is there.
There is a rule, Lordship. But it should be highest. I don't know. Per year, it should be high, differential high, Lordship.
There is an incremental height every year.
Yes.
15%, 10%.
Yes, Lordship. It should be high.
That is automatic. He'll give a rate that will automatically keep on going up.
That will go on. And again, Lordship, that
tender knowledge.
That will go, Lordship, in that case, Lordship.
This will go. You give it to him.
Which will go, Lordship?
This order.
No, Lordship, this order is good. This order is in other part, Lordship, is good, Lordship. 48 fee is not.
If that is not applicable.
Why?
If that is, you say it's not applicable.
No, 48 fee is applicable. Later part, I am saying, Lordship. Later part, that the Deputy Commissioner cannot put this this call deposit of Sri Pramod Chandra Das will be forfeited. That forfeiture part.
That we will take care of. Don't worry.
That cannot be done. But here, Lordship, 48 fee, Lordship.
If the power of the Deputy Commissioner is not there, how can he pass this order? You have little bit, one
No,
Fine.
that part, that has been decided lordship in the first order lordship, in the similar case lordship, that's what I am.
So if now you say that the deputy commissioner has forwarded something, we'll again sit over the matter. Both are not sinking.
No lordship, here in fishery.
Here he has decided.
Lordship,
He has decided.
Lordship.
He has decided. Deputy commissioner has decided,
Lordship.
right? Now you say the deputy commissioner has sent a proposal in his name. We are not going to consider.
lordship.
We'll consider everything.
No lordship,
Why not that
in
same-
fishery matter, lordship, all the fishery matters which I am doing lordship. In fishery rules, we go by the fishery rules, rule 12 lordship, lordship may go through it. Lordship. As per rule 12, deputy commissioner has the right only to go for a tender.
That is why I'm saying.
For tender, he has the right to recall also. Yes, because he has the tendering, he can issue tender, so he has the right to tender. Recall also, lordship. That part we have no issue, lordship.
That tender recalling will be qua the issues arising in that tender.
Lordship.
It cannot be something which is to do with the bids. Bids will be settled by the government in the fisheries department. Bids will be finally settled by the government in the fisheries department.
Yes, lordship, yes.
Right?
Lordship.
Tender issued, something is there. He finds it erroneous, he can withdraw that tender. No issue.
Lordship.
But the bids he cannot touch. He will have to forward to you. How could he pass this order then?
That what my friend will say.
No, you
No,
tell
no,
me.
lordship. Here deputy commissioner has passed the order.
Then you say now the deputy commissioner has sent me the second tender
Yes,
details.
yes.
Now we will examine.
Second, we are satisfied with the second order, lordship.
Mr. P. Sharma, Learned Standing Council, Fisheries Department shall without fail bring on record an affidavit on behalf of the said respondents invariably on or before 21.
Lordship, it will be too early, lordship.
Not too early, no,
No,
because
give me 10 days, lordship. At least 10 days, lordship. How can I? It's a government.
okay, 10 days, 28/9.
Okay.
28/8/2024.
Lordship.
In the event the registered to list this matter again on 30/8/2024. In the event the affidavit is not filed by on or before 28/8/2024, on 30/8/2024, this court would require the personal appearance of the competent authority in the Fisheries Department to explain the query, to answer the queries of this court in the matter.
Highly obliged. Much obliged.
Iman? Yes.
As part of that's a WhatsApp message, dispute case number so is returned in FR height number so dated 30/12/2023 as informed by the second officer, namely SI S. Borhia of the risk. So just now I inquired with my client, he has not received any notice because if
You check up in the PI code. You are entitled to file an RRG petition. Check up, come back. We'll keep this matter pending. Ms. S. Borhia on instructions has submitted that the investigation in dispute PS case number
3570
3570 of
17
2017 on completion of investigation, was submitted in FR before the competent court. Also, Mr. Kolita submits that he be given a week's time to receive instruction about the said development taking place in the matter. Also, registered to list this matter again on 2/9/2024, on which date Mr. Kolita shall apprise this court about the further development taking place after the submission of the FR in the matter. And madam, what about this?
The amount has sent back to the ZAD, General Administrative Department also.
For what?
For when the petitioner was not found on the proper address, then the district commissioner wrote a letter to the ZAD department, and the ZAD department directed to send back the sanction money amount, lordship.
Yes, what is that? She was not traceable. Where is she? She is in.
She's here.
Then
She's here. Okay.
lordship, General Administration Department had to
It is the
decided
party
when
responsible
the
for-
amount will be there again sanctioned.
Okay.
Yes,
We'll do one thing. The instructions received by Ms. S. Burwa, learned counsel, government advocate appearing in the matter, is to the extent that the 50% of the award amount on being sanctioned was ready to be authorized to the wife, to the petition number 2 hearing. Petition number 2.
Petition number 2.
No, petition number 1 hearing. However, on an attempt made to contact the petition number 1, comma, it was given to understand by the officer in charge, Margarita PS, that the petitioner had already left Margarita for Nepal before, 5 to 6 years before 2007. So in that view of the matter, the amount not being disbursed was refunded to the General Administration Department wide by the Deputy Commissioner Tinsukia to the General Administration Department. Also, in view of the said stand as taken by the petition in the matter, it is directed that the petitioner's hearing shall, within a period of 10 days from today, appear before the Deputy Commissioner, Jurisdictional Deputy Commissioner, District Commissioner, cum Collector, Tinsukia, and submit a representation before the said authority, praying for release of the said amount. The said representation shall be forwarded by the Deputy Commissioner to whom? To the General Administration Department, Government of Assam.
Respond number 1.
Respond number 1 within a period of 15 days from the date when the petitioners appear before him, along with a certified copy of this order. First off, the General Administration Department, on receipt of such representation from the representation of the petitioners from the District Commissioner Tinsukia, comma, which will go to establish the fact that the petitioners continue to remain in India, comma, shall release to the petitioners the amount as awarded by MACT by the
1,96,000.
as awarded by the MACT Dibrugarh in MAC case number 15/98 with the interest as attached to the said award in full. Full stop. 30 days bola na? 15 days may appear. GAD 30 days. 30 days. 2 months may cover. Shall release to the petitioner the awarded amount within a period of 2 months from the date of receipt of the representation, along with a certified copy of this order. Registered to list this matter again on 45 days. 45 days. On 39/2024 for further consideration. On the next date of listing, the learned counsel for the parties shall apprise this court about the development taking place in the matter. Yes.
I'm appearing for the GAD,
GAD.
respond number 1. This matter is an old matter, my lord. So basically, we were not aware of this case. I've just been informed, my lord, that we are in this matter. My name, my lord, may be recorded as.
Mr. A. Fukan appears for the GAD authorities, and he shall also forward a copy of this order to the GAD authorities for compliance.
My lord,
Also,
our name may be recorded.
the name of the advocate as standing counsel GAD shall be reflected in the cause list on the next date of list. A copy of the instruction with punished by Ms. S. Burwa is kept on record and marked as X.
The earlier order passed by this honorable court in 2005, 12% interest was.
Amount, ऊपर में लिखो ना, amount along with interest at the rate of 12% per annum with effect from the date the award was so. From the date, when was the award given effect to?
Word was given.
তেতিয়াৰ পৰা তোমাৰ ওচৰত কমিউনিকেশ্যন আছে বহুত তেতিয়াৰ পৰা হেৰি কৰি আছে
3/1/2001.
Award date.
Yes.
No, no, it was given effect from when? %12 per annum, along with the award, will carry interest at the rate of 12% per annum from the date of knowledge till realization. Attached there to bonus. Take it, so that award 12% was given by the MACT. Now your apprehension will be redressed, whether they are in India or not. If they don't file a representation, you are not required to do anything. If they file a representation, you will have to act on it. Within 2 months, the money has to be paid with 12% interest. And if you don't do it by next month, the 12% will go up. That's all.
Right.
Mr. Fukan, take note. Take note. That's you can still smile. Miss Burwa may be having some trouble. You can still smile. For you, there is another 15-20 days left for you to get tensed.
I'll take a copy for the.
You do whatever you want, but you need not be tense today. You can have time. You have time till September 30th. You can be smiling till thereafter. Maybe you will be a bit more tensed up. Yes, madam. Yes.
Earlier, this Honorable directed them to consider our case as per consideration. But since then, my lord, we are submitting various requests not considered.
No, Mr. Shama submits that.
Now, they have, my lord, they say that now they have received from PAN, my lord, they will consider it, my lord. They write a plain, my lord, of the affidavit. They say, my lord, they have received from PAN now.
That's what to do.
So the direction may be given, my lord, to
Examine and pay.
Yes.
As heard Mr. G.N. Sarwala, on a counsel, senior counsel, appearing for assisted by Miss S. Todi. S. Todi, learned counsel appearing for the petitioner. Also heard Mr. C. Sharma, learned counsel appearing for
My lord, K. Vishwakarma.
K. Vishwakarma, sorry, appearing for all the
respondents.
All the
2,
respondents.
3 and 4.
Two respondents number 2, 3 and 4. Also heard Miss S. Borua, learned counsel appearing for the respondent number 1. So, respondent number 1, Ange Kaldana. So, as agreed to by the parties in the present proceeding, this writ petition is taken up for final consideration and disposal. Also, the petitioner in the present proceeding has claimed for has prayed for a direction upon the respondent authorities to clear his outstanding dues amounting to rupees. This is the same issue in all the three cases.
Yes.
Amount will be changed. Amounting to rupees 25,19,602, which is in areas for the work for the works undertaken by him for the respondent authorities during the year 98-9 to 2002. Also, the petitioner prays that the said amount be so released to him with interest at the rate of 12%. Also, the respondents, by way of filing an affidavit in the matter, had disputed such claim of the petitioner on the ground of delay occasioning in claiming the said amount, and accordingly, it was stated that such claim as made by the petitioner in the present proceedings is barred by limitation. Also, in the said affidavit, it was also highlighted that the amounts due to the petitioner could not be released to him on account of a financial crunch suffered by the board, and accordingly the same remained in arrears. So,
Now
Mr. Vishwakarma, learned counsel, appearing for the respondent number 2, 3 and 4, has on instruction submitted that the board is in receipt of funds, and accordingly the claim of the petitioner can be given its due consideration and the areas cleared. However, Mr. Vishwakarma submits that the said bills being the claim being old claim, the board be permitted to carry out a verification process for the same, and thereafter release the amount due. So what about interest?
But if they are entitled to.
Due. And he also submits that in the event the claim of the petitioner is found to be admitted, he would be entitled to interest as claimed for. Also, in view of the said submission is not disputed to by Mr. G.N. Sahibullah, who submits that the petitioner has been unnecessarily harassed for such long period of time on account of non-release of his admitted dues. Also, in view of the above agreement arrived at, in view of the submissions made by Mr. K. Vishwakarma, Learned Standing Counsel, for appearing for the respondent board, the board is directed to carry out verification of the bills as submitted by the petitioner in the matter, and thereafter, in the event it is found that the petitioner, the claim made by the petitioner is admitted, to release these admitted amounts to the petitioner along with interest at the rate of 12% from the date the same was so due. Also, the said exercise shall now be initiated and concluded by the respondent number board within shall be initiated and the verification process concluded and the payments of the admitted amounts made to the petitioner along with the interest thereon within a period of 3 months from the date of receipt of a certified copy along with the representation from the petitioner here. Isme khali ek kaam karna tum. In the other two affidavits also you have filed affidavits,
Yes.
same affidavit.
Same
only amount will do.
A item number 36 है, Batiman 37 में amount खाली change होगा.
36 and 71.
And 36 and
71.
71. There is 37 also.
37 and 71.
71. 71 में 3 matters amount change होगा. Oh, तुम लोग
Lordship will show the name of, I mean, by the phone number one.
for Mr. S. Bora for respond number 1.
All the.
You does ने क्या S. Bora लिखा था ना S. Bora का for respond number 1.
I oblige, my lord.
Wait, please.
So,
Nothing is there, my lord. Since 2014, this matter is standing, my lord.
Lordship may kindly see the Lazima court order dated 2/8/2024.
Wait a special.
Last order. Lordship may be permitted to make,
what is the issue?
In 9/8 order, my lord.
this, petitioners and the local villagers of Pangram village, your lordship. And within a diameter of 3 kilometer radius, your lordship, 22 stone crusher units were developed in a short span of time, which has caused serious degradation, not only of the environment, but their own agricultural land and also noise pollution, your lordship.
Now, you are, after filing of this case, 10 years have passed.
Yes.
What is the further
Yes.
degradation?
10 years. Sir.
What is the further degradation taking place? Any interim direction passed by this court?
no, yes.
Then,
No interim direction is there.
then pollution control board, what is the stand? Have you made pollution control board a party?
Yes, yes. Yes.
Huh? You are appearing for the,
I'm appealing for the 11.
you are appearing for 11. Okay. And Mr. Saivala, you are appearing for all the private respondents? 14?
I'm appealing for 16, 20, 24.
16? 24?
And 30.
12, 13.
12, 13, 15,
And 28.
18, 19, and
My lord, we have filed affidavit in this matter, my lord. They are
replies filed.
Yes, my
Have
lord.
you filed replies?
Reply they have not filed.
Why?
And
No,
moreover, my lord, they are
service
not
is
the person
pending, your
active
lordship.
in this case, my lord. They have raised an issue of pollution caused by this alleging caused by these units, stone crusher units. But so far, we have given our, my lord, affidavit NOC consent for operation. My lord, respondent number 13 file affidavit, page 6 and all. My lord, moreover, this
documents they shown in the, my lord, annex in the repetition, that the bunches of papers, that medical certificates and all, my lord, these are not belong to them, my lord, these three petitioners. The three petitioners are not the, my lord, affected party. So therefore, the issue raised
Is in a
cannot be
form of a
exceeded.
PIL.
Yes, my lord, that's our stand, my lord. So therefore, my lord, there's nothing survive in this, in my humble submission, my lord.
Yes.
Email, hesitate.
Yes. My lord, this is not the case that the petitioners are some person outside the village. They are also the persons of the village.
Show me how you are a person aggrieved.
No, because
If the authorities have given them a consent to operate,
no, they have lordship as such-
there is no consent to operate.
because they have their affidavit in opposition, your lordship. Lordship will take.
Mr. Counsel, for establishment of a stone crusher unit, what are the basic requirements?
They will have to take permission from the industry department.
Have they taken that permission?
Nothing. Your
Have you
lordship.
alleged that they have not taken that permission or it is operating without permission?
That is.
Is the pollution control board clearances on record?
Yes, pollution control board has filed an affidavit in opposition, your
What
lordship.
do they say there?
Their stand is that out of this 21, your lordship,
Ah,
we have said that there are 21 industries have been set up in a show. They said that out of this 21, in respect of 13, they have given consent.
what about the rest?
Rest they don't know. Yeah, but the
Yes,
about
pollution
their-
control board, who is there?
whereas
Mr.
others
Borua.
have already appeared, your
Yes,
lordship.
Borua. Mr. No, he says 13 out of the 20 somewhat odd. 13 were given consent to operate. How are the others operating then? We'll have Mr. Borua. We'll hear it in his presence.
In the meantime, you may be allowed to take steps on service of respondent number 27. Only 27 has been remained, your lordship. Lordship may
Go and serve it in his stone crusher. Dusty, we'll not ask you.
Thus, we have tried, your lordship, but they have not received. We have filed an affidavit in this regard also.
Okay, fine. Let it be this.
That best quality, it may be a PI, against the other aspects also, in that case, it may be PI.
And there is no
No.
stay, your lordship.
If his contention is correct, that consent to operate is limited to 13, not to the all. We will leave that 13, the rest we will consider.
Legal others also.
You be concerned with you.
Yes, sure.
Hardy Learned Counsel for the parties. Mr. S. Borua, Learned Counsel for the Pollution Control Board is not present. And it is stated that he had to leave the court on account of certain personal inconvenience. So accordingly, registered to list these matters again on 27/8/2024. So on yeah, go idea. 3/9 go idea. 3/9/2024. 3/9. Any interim orders? No.
Obliged.
Mr. Counsel, you are on a very thin wicket.
Yes, yes.
A very thin
I
wicket.
know, my.
But you're this one submission, I stopped myself. Let us examine.
Obliged.
Come on. You will left over names. Or continuation. Yes, Mr. Soma.
Lordship, may kindly peruse order date, my lord. 22/12/2023, my lord.
Yes, CBI has filed and
Yes, my lord. In
Then-
this case, I am appearing on only for the petitioner number 3, my lord. And the petitioner number 3 has been found dead by police on May, 1st of May 2022, my lord.
petition number 3.
Yes, my lord.
So what is left here? Criminal
He
proceeding.
was arrested in connection with my lord Lala PS case number 110/2022, my lord. Later on,
None appears. I don't think so. This can be processed. Criminal matter, nothing against you now.
my lord.
Finished.
Already, your lordship see the prayer portion, my lord. A part of the prayer was to direct the CBI to take over the investigation, my lord.
By petition number 3 also.
Yes, my lord.
None has appeared for response petition number 1 and 2. However, Mr. M. Sharma, Learned, M.K. Sharma, Learned Counsel appears for respondent petition number 3. It is submitted that in these cases, you were the accused.
Yes, my lord, as per the CBI report. my lord.
Submits that during the pendency of the present proceedings, the petition number 3 had died. So accordingly, there being none to press the present proceedings, the writ petition stands dismissed for non-prosecution. Can't help it.
Oblige you.
This is with regard to that smuggling of coal and all limestone to Meghalaya.
Yes, my lord.
Is it disclosed?
May it please your lordship. This is about the rejection of my candidature for an LPG leadership, my lord. The impugned order, my lord.
Affidavits filed.
Yes, my lord. My lord. We have filed a reply. My lord.
At the Learned Counsel for the parties, it is submitted that anybody left to appear?
Yes, madam. I am appearing, madam, for response number 1 to 4, madam.
R5 service is complete, but he has not appeared. my lord.
Okay.
Right.
It is seen from the office note dated 13/8/2024 that the service upon respond number 5 is complete. Also, the Learned Counsel for the parties submit that the affidavits of the contesting parties have also come on record. Pleadings in the matter have been completed by and in between the parties appearing in the proceedings. Also, accordingly, registered to list this matter for admissions after 3 weeks, 2 weeks on a date to be fixed by it.
But there is an interim order, my lord. But
Interim order passed early. Oh,
they are enjoying, madam, interim, madam.
16, 1, 2. On to me, 13/9/2024, interim order passed earlier to continue till the next date of this thing.
Leave.
Your lordship. Your lordship.
Mr. Chakraborty, you are appearing for which respondent? No, you are appearing for which respondent?
1, 2, 3, and 4, madam.
1, 2, 3, and 4.
Yes, madam. And Bodhago, madam.
No, Bothago. But your name is not shown here. Okay, fine.
Your lordship, in this case.
Have you filed the amended cost title?
Yes, yes, my lord. My lord, in this case, service of notice upon respondent number 2 is not completed. Therefore, a fresh notice may be issued.
Where is the amended cost title? Okay. The notice was issued from seen the office note dated 13/8/2024. Office steps notice was issued upon the respond number 2 on 9/1/2024. However, till date, neither AD card nor the unserved notice has been received back. Accordingly, the petitioner is to take fresh steps for service of notice upon the respond number 2. Also, the steps be taken within 3 working days from today. Registry to issue notice by way of registered post with AD to respondent number 2. Thereafter, the matter be listed after 4 weeks along with the status report with regard to the service of notice upon the respondent number 2.
Does this service may be allowed?
Contempt, we can't.
Item 50.
May it please.
Madam,
Yes.
There was the price, actually what has happened for.
Yes, Mr. Talukdar, what has happened?
Yes. My lord, in fact, I have taken the instruction. But what had happened, as appears from the record, the relevant date, my lord, is 29/8. On which, my lord, postal endorsement.
No, postal endorsement is
I think 29/8, my lord.
29.8,
Yes.
29.8, yes.
Yes. My lord, in fact, before that, a development had taken place. There is a, my lord, transfer of the charge. If the lordship takes up, my lord, even lord.
Okay, why did he pass that order?
My lord, on that count, I will file affidavit. Your lordship
No.
directed me, my lord, to take.
There are 2
instruction.
points in the order.
No, in fact, my lord, what has happened, this I have received, my lord, through WhatsApp. Even, my lord, till now, I have not filed any wakalatnama on his behalf. So if your lordship permits me, my lord, I may file an affidavit. Oh, my lord, what was the reason why he had filed that, my lord, passed that order?
Mr. S.K. Talukdar, in terms of the query raised by this court, wide order dated 12/8/2024 as to why the sole respondent herein had refused to receive the notice sent by this court, has received instructions and submits that has received his instructions. It is submitted by Mr. Talukdar that the sole respondent herein was transferred from the post of, was required to hand over the charge of the post of Zonal Joint Register of Cooperative Societies, Jorat, on 9/8/2023, and accordingly, he not being holding the said post of Journal Register of Cooperative Societies, Surat, he was never, he is not in a position, he had not received any such notice, and accordingly, there was no occasion for him to refuse they refused to receive the notice in question. Also, Mr. Talukdar submits that he be given a week's time, 10 days time, to bring on record an affidavit in the matter on behalf of the respondent, sole respondent, explaining as to why the communication dated 5/8/2023 was so issued, which is now contended to be in violation of the directions passed by this court, wide order dated 25/7/23 in WPC number 4083/23. Accordingly, registered to list this matters again on 28/8/2024. Also, it is provided that in the event the said affidavit is not brought on record by on or before the said, it's got 29 video, before the next date of listing, the personal appearance of the respondent would be so directed on the next date of listing.
My lord, can I ask for a copy of the writ petition, man?
No, he can, but he should give me.
Go outside and fight it out.
On last occasion, your lordship have asked the document.
We are handicapped, my lord.
You file a review for that order. Otherwise, that order has to be complied with. You have admitted the abuse. Will not accept this. Just writing down 5-10 paragraphs
We have
and
to
saying
file-
that is
we have to
compliance
file-
will not be.
We have to file review, my lord.
We do whatever you want. I have not seen this.
Because we are only.
Mr. I'll say, Mr.
Right.
Dr. Leonard, Council appearing for the respondents have submitted an order dated 15/8/2024, saying that the same has been issued in compliance with the directions passed by this court passed by this court-wide order dated 19/12/2022 in WBC number 1872/2022. This court has perused the said order dated, perused the contentions as contained in the order dated 15/8/2024 and finds that the same is not in compliance with the directions passed by this court. By the above noted order. Also, accordingly, the said order is not accepted as to be so passed in compliance of the directions required to be complied with by the respondents. Also, at this stage, Mr. Datta prays that he be given 2 weeks' time to further receive instructions in the matter. Accordingly, while rejecting the order dated 15/8/2024 placed on record, comma, the petitioner, the respondents are granted further 2 weeks' time to take further action as may be called for in the matter for compliance of the directions passed by this court. Also, raised it to list this matters again on 6/9/2024. A copy of
Some more time.
6/9. One copy of the order dated 15/8/2024 is kept on record and marked as X. Kiman Kujilu? 6/9. Yeah, 13/9.
52.
Hey, please, Your Lordship. That's from the last occasion, the honorable court wanted to know whether we had sent it to the finance and whether we have asked for Lordship supplementary demand, Lordship.
Yes, what is it?
Finance Department, Lordship.
Finance is a party here.
Finance is a party, Lordship.
Who is appearing? Yes, what happened after that?
Mr. Dilip Kumar Bora is dealing for Finance Secretary, Lordship. That is in the first page, Lordship. His name is there in the first page. Second line, Lordship.
Okay, madam, what happened after the supplementary demand proposal was received?
It has gone to the budget section, Lordship, now.
Wherever it is, when did you send it?
Lordship, it was according to them, Lordship, this has been given to the director, Lordship. That's only.
Where is the order violated, madam?
Your Lordship,
Page 20.
page 20 is the operative portion of the order. Third last paragraph.
Yes. Why you're otherwise you are not required to take instructions. You are a party here. You are appearing for which respondent? So why he has not furnished you with any instructions? The proposal has already reached. He has to give it to you. It's already 4:15. I can't detain you now for instructions. Okay. Mr. P. Bhagwati, Learned Counsel.
M. Bhagwati.
M. Bhagwati, Learned Counsel for the petition, for the respondent number
Lordship, 1 and 2.
1 and 2 submits that the bill, that for clearing the amount receivable by the petitioner, clearing the dues, admitted dues of the petitioner hearing, a supplementary demand has been placed before the Finance Department, which is pending consideration. Also, Miss R.M. Borua, Learned Counsel appearing for the respondent number 4, shall receive instructions and place the same before this court on the next date of listing as to the steps taken by the Finance Department after receipt of the supplementary demand from the respondent numbers 1 and 2 in the matter. Who's- Mr. Bhagwati, will
Take it from me.
list this matter again on
Your Lordship, a shorter date if possible.
28/8/2024. Give her a copy so that she
Lordship,
also has
Lordship.
it. Ms. Burua, you collect a copy from me. Yes, what happened?
Lordship, I have obtained instruction,
Hmm.
the department has not received any application. Field it and furthermore, Lordship, they have to approach the Ministry of Corporate Affairs.
They have approached the Ministry
No,
of
Lordship,
Corporate.
they have not approached.
They have not approached.
No.
Well, page 28 is what we have stated, madam. We can't approach Melon because it's through online and there is an website. error.
Online is also an approach.
No, there is an error shown in the.
Why was I not corrected on the last occasion when I said that?
I could not follow what your lordship have observed.
My English is so bad.
No, well, I could not.
So what happened? How will you get it?
Lordship, now he has to apply to the Ministry of Corporate Affairs.
How?
Delhi.
Because many.
That I'll provide you in the links and other.
No.
Because
He says that the website is not working.
that is, Lordship, that was on last occasion, it was not informed me. I was informed by the officer that now there is no application pending before the department. Secondly, they have, for obtaining a duplicate certificate, they have to approach the Ministry of Corporate
Okay,
Affairs.
they'll approach. How will they approach?
I'll provide all the.
Mr. S.K. Lanak Council, who was requested to receive instructions in the matter from the Register of Companies as regards the application submitted by the petitioner herein for being furnished with a duplicate certificate of incorporation of the company. On instruction submit that such application has to be made before the Ministry of Corporate Affairs. So he undertakes that he would provide the Lanak Council for the petitioner with the site details wherein such application is to be made and of the address of the authority to whom the application, hard copy of the application is to be sent. So the petitioner hearing shall within 1 week from today submit his application in the matter before such authority as may be now indicated in the matter by Mr. S.C. Kyan. So the respondent authorities shall thereafter consider the application of the petitioner and if it found to be satisfied with the contention so made and the company is an incorporated company, proceed to issue the duplicate certificate of incorporation by following the process mandated for the same. So within a period of 15 days from the date of receipt of an application from the petitioner. Registry to list these matters again. On 16/9/2024. Mr. Kyle, can you get that instruction for us on the next day, whether this Mr. Ken is again requested to receive instructions from the Ministry of Corporate Affairs as to whether the petitioner has submitted the application either online or a hard copy or by registered post and the progress made in processing thereof.
Lordship, I have a small prayer. Look, instead of 16, can it be on 19th or 20? Because on 15 and 16, I will be out of station, my lord.
On 18. 18/9.
Lordship, registry may be directed to Somaina because.
The registry is directed to reflect the name of Mr. S.C. Ken as standing council ROC.
Not
ROC.
Can it be on 19th, my lord?
You're going on 15.
I am going on 16, my lord.
16.
16, 17, 18, I will be.
19/9.
Lordship.
Obliged.
Any interim orders to be continued?
Interim order, no.
Madam, to be fair, I have checked up.
Were you unfair at any point of time?
I mean, absolutely, no, I'm not being unfair.
No, were you unfair at any point of time?
Never. There is nothing on record to show that apart from a hard burning of an act of mine on acting on a promise which could not be satisfied with the four walls of law, but page 54 and 47 are representations to authorities of the state where I have cried in equity lordship allows graciously, my lord, that they may consider my representations, else it's a case for dismissal straight away.
40?
47. Deputy Commissioner Nogao
2nd of April, 2nd of July, and 54, the chief engineer concerned, jurisdictional, I have represented so far and no further. That's.
Yes, madam, what is your
Also,
inquiry?
I have a copy of the report. All the developments that have taken place, it's all there, and the relevant portion would be in page 6. Selection of the plot of land.
Oh, you have paid bribes.
My lordship.
You have paid bribes.
He's putting it on record. He should be held guilty for that.
So we'll proceed against him.
That could not be proved, your lordship, it's there. in the
Certainly,
inquiry.
certainly. What he has taken, we told him earlier also, he put it on record, face the consequences. Not even
Okay.
that, he's told the police and the authorities.
Today I'm not doing anything. We will consider this matter on the next day.
Well, may I have a copy of, I mean.
No,
identified
no,
affidavit?
that is for me,
What?
not for you.
Okay.
You stick with your that prayer in the repetition that
We
you
don't
had
have-
paid bribes, video calling also.
Absolutely.
Hmm. Registered to list this matters again on 3/9/2024 for further hearing. You have to buy slip
Could
like
it
it.
be A little later.
3/9.
No, I will not be here.
I'm only passing an order. You need
I
not.
will not be here.
When are you here?
After 3/9.
3/9, 5/9. I'm dismissing it.
Yes, yes. he told
Today
me.
I'm not troubling me, myself.
Lordship may pass
and
the
they-
orders. because-
No, no, I'm not troubling them. They have enough.
CAB means the lordship
No,
may
no.
pass orders, that's what.
Obliged.
Those days gone now. I'm not make a mistake that I made a mistake when I started off.
Obliged. Lord.
May I have the report? And for respondent number 1, my lord. I
Mm.
received the instruction, my lord.
Mm.
As per instruction, budget will be released within 3 working days, my lord.
This is that ex gratia payment thing, na? Also, Miss,
PR Mohanto.
do you think I forgot? Miss Pia Montal on a council for the petition, for the respondent submits that, so on instruction submits that the budget for release of the amount, ex gratia amount to the petitioner hearing would be received by the Revenue and Disaster Management Department within 3 working days from today. And thereafter, the said amount would be authorized to the petitioner at the earliest. So it is required that the matter, the said submission of Ms. Monta is accepted and registry is directed to list these matters again on 2/9/2024, by which time the order, the directions passed by this court-wide order dated 14/11/2022 in WPC number 5054/2022 is to be complied in full. And the compliance report is to be placed on record. Also, a copy of the communication dated 16/8/2024 furnished by Ms. Monta is kept on record. Mr. J. Hendrick, Learning Council, appears for the response number 2. And Mr. Council, next day you get the money and you don't appear, we will again take up some other proceedings in this matter. This practice I'm not liking. Once the order is complied with, I don't find the Learning Council coming up and having the courtesy to tell this court that the proceedings have been completed. Right? Kindly don't develop those habits.
Obliged. Obliged.
May it please the lordship. Lordship was pleased to
Uh-huh.
the review petition.
Heard Mr. H. Roman, Learned Senior Counsel, assisted by Ms. We are putting it, Mr. P.W.A. Muzumdar, he was there. P.W.A. Muzumdar, Learned Counsel, appearing for the petitioners, for the petitioner. Also heard Mr. B. Kaushik, Learned Standing Counsel for the Secondary Education Department, appearing for the response number 1 to 3. Also, the Learned counsel for the parties have been heard at length. Also, raised it to list these matters again on 9/9/2024 for delivery of orders.
Deeply obliged, Lordship. My lord. My lord, file the reply. Because today I have been engaged and I have gone through the documents. Some counter has been filed by the railway, your lordship.
When?
Just now I have gone through.
No, you have gone through. When did they file?
Yes, today, your lordship. I have filed my wakalatnama.
No, you have filed your wakalatnama today, we understand.
On the,
But the affidavit of the railways was filed on 22/11/22. Then,
my lord, I have to only, I need 7 days.
My lord.
File the reply.
what is the issue?
Issue with regard to your lordship.
My lord,
Madam.
this case don't survive your lordship.
Mm, that's what I want to know.
I'll make it very short, your lordship. Your lordship may kindly turn to the, your honor called order 26/8/2022, my lord. It is
order?
flag yellow.
Our
flag.
order?
26/8/2022. That was the status quo. Interim order was passed on that day. That is
Okay.
26/8/2002. Your lordship will.
May I read you?
Apply. And
Young counsel is there, let him read.
second para, your lordship, second
Yes,
para.
Mr. Singh.
Accordingly to the petitioner, the license agreement entered by the petitioner with the IRCTC authority is valid till 15 November 2022, your lordship. Because they don't have a valid license, only on the ground that there is a tri-party agreement,
Okay,
they got this order.
so till 15/11, they had a license.
Then finish, your lordship. Now we may be allowed to go for the fresh tender.
Okay, notwithstanding
Initially,
the same
we have
assumption.
posted for the tender, but
That's
we
all.
discharged.
Now,
your
the
lordship.
tripartite is only for handing over so and so, not for any other. On the contrary, I find that there is an agreement entered in so and so with the petitioner on 16th, according to which is entitled to over until the date mentioned in it. As such a prima facie case. Okay, madam, now tell me, your license expired on 15/11.
Kindly have the agreement, tri-party agreement, your lordship kindly have.
Yes, come show me.
Yes, your lordship.
Page,
Page, your lordship. Chapter 1. Page 23. It begins with page 23.
Hmm.
The relevant part, your lordship. Page 24.
Hmm.
There is no time has been given.
Yes, there is a time given,
No, your lordship.
clause 7.
Clause 7, your lordship.
The license shall continue to provide
your
catering
lordship,
services.
How is it possible to 2nd May 2020, 2003? And it is continuing. How is it possible? The agreement existed in the year 2017 and they stated 2nd May 2003. 2003 for the period of licensee awarded by NF Railway unless terminated earlier by senior DCM. So and so NF Railway.
Okay, where did this court find out this date of 15/11/22?
Your lordship.
From where? That is an error. Will
No,
we
no,
accept?
not at all, your lordship.
It
No,
cannot
but
be,
they-
it cannot be a correct date, 2/5/23,
Your lordship.
2003.
Thereafter kindly have page number 31 of the.
No, no, madam, this date 2/5/23, 2003 cannot be the correct date because this agreement was executed only on 16/11/2017.
17.
So there is an error here.
There is an error,
Ah.
May and year. How is it possible? May and year. 2nd May.
Okay, tell me. This date, you say is correct.
No.
If this date is wrong, the entire agreement is gone.
This date is not correct.
So
and
the entire agreement is void.
And there is no condition
Okay,
of 5 years.
next page, what do you want to show?
Yes.
Which is the next page you want to show? Page?
Page. Kindly have page number
Yes, madam.
31 of the policy, according to where they based. 31.
Okay, ma'am.
Page 3.89. I read, the existing railway operated base kitchen units and land allotted for setting up new kitchens shall be handed over to the IRCTC for a term of period 10 years, which shall be extendable for another 5 years at a time of subject to mutual agreement. There shall be a provision for taking back the base kitchen and.
Are you operating a base kitchen?
No, I am RR, your lordship,
You are just a retailer.
RR. Railway refreshment room.
That is it. So
Refreshment
you don't operate you won't cover by this 10 years.
And page number kindly, your lordship, come at page number 27. Page number 27, objectives of the policy 2017. May I read the 4th paragraph? IRCTC shall be responsible for catering services through mobile catering units, base kitchen, cell kitchen, refreshment room.
Okay,
and-
then what happened?
Your lordship, thereafter, he did not disclose all the orders. Only he has shown the part of the order which is in his favor. Thereafter, your lordship, if your lordship may permit, that's why I was saying, may I read your lordship? Mr. Singh submit that license of the petitioner has already been terminated before the agreement. Tri-party agreement dated 16/11/2017 is only for facilitating handing over the stalls of IRCTC. However, there is nothing on record to substantiate the above argument. Therefore, I am unable to agree with the submission of Mr. Singh that the tri-party agreement is only for handing over the stall to IRCTC and not for any other purpose. On the contrary, I find that there is an agreement entered by IRCTC and NF Railway with the petitioner. 16th November 2017, according to which he would be entitled to operate refreshment move till the date mentioned in the agreement. They have not mentioned any date in the agreement.
That the one you took me through. Okay, now read further.
As such a prima facie case has been made out by the petitioner, at least to examine his claim to continue with licenses till 15/11/2022.
So, madam, this court has set 5 years.
5 years, but the policy,
Madam, have you filed a review for this order?
Your lordship, because I have got the file.
Fine.
And I only need 7 days
No.
for the reply.
The last date the council was here.
But I have been
No,
subsequently.
madam, he did not say that there is some change
Only
going.
your lordship, short time, your lordship, my humble request.
I'm sorry.
Because it will be.
There is,
just-
we'll give you time, we'll give you a month's time,
No.
but the interim order is being vacated. Because you are operating beyond the time given by this, even by this court.
Your lordship, for a moment, only 7 days I want, because I have to go there are several matters like this, they are doing. Because of the lack of the agreement, it was between the NF Railway and petitioner. is third
Madam, how
party.
can I extend something which is already
Because the
dead?
policy has given 391, 10 years, and thereafter.
That
still
is for base kitchens.
The allotment, I have set the objective. Your
And
lordship. Your
this
lordship,
court, while passing, giving you interim direction, had limited it to 15/11/2022.
only on the base and continue will 15/11/2000, but that should be required some inquiry, your lordship, according to the.
You are
policy.
practicing in this court?
No, your lordship,
You're coming from
Prayagraj,
Huh?
Allahabad High Court.
Allahabad High Court.
Your lordship,
So, madam, we'll have this matter again on,
9th September, your lordship. Because there are 4 matters here.
no.
Fine,
We'll not give you, because this public interest is involved.
fine,
You asked for a week's time, I'll give you a week's time.
okay.
We'll have this on 27th. You bring your records, whatever you have.
Deeply.
I'll spread for madam your name,
Shikha, Srimati Shikha Singh, Mrs. Shikha Singh,
Sikha
Singh.
Singh. Miss MS Sikha Singh, learned counsel for the petitioner submits that she be given a week's time to bring on record the rejoinder to the affidavit filed by the respondents herein. Was a prayer accepted, raised it to list this matters again on 27/8/2024, on which date the contention of Mr. Singh that the agreement entered into with the petitioner herein had expired on 15/11/2022, and she cannot be permitted, and he cannot be permitted to continue further, shall be so considered after perusing the reply, a rejoinder that would be filed in the matter by the petitioner.
Meanwhile, your lordship,
The interim order passed earlier to continue till the next date of this. All right.
very much.
You have come from outside, ma'am, that's why I've accommodated you. Otherwise, I would not have.
Highly grateful.
Yes. Mata. Mr. Kolta, Mr. Roy, I'm sorry.
56.
I'm sorry today.
No, my lord, lordship, we have received the competition lordship dated 11/7/2024 on 31/7/2024. Lordship has
We have
directed us
already,
to-
my lord, given the computation, only they have to deposit.
Lordship, may after 14 days, because.
Well, what
lordship
is
has-
that? If you deposit now, we are closing it.
Lordship may fix them at the 1st September, lordship, first week of September.
Why? You're going to challenge this?
No.
Then,
Lordship,
any dispute on this?
yes. lordship.
You're paying.
Lordship, we're paying lordship, but the client has impacted there's some amount. They have some disputes regarding the.
Array, I was giving you time for the last 2-3 months to bring this on record. You have not been able to.
No, lordship, now.
Now they have given, from where
Given
does
the
that those
calculation.
amounts coming out? That means you had submitted suppressed facts from this court
No.
that you had made deposits to this account.
Lordship, that's why lordship will take the first week of September. lordship.
We will now
Because-
direct that you are going to
because
pay
lordship-
this
lordship
amount.
Direction for within deposit within 4 weeks. lordship.
Hmm.
And we have received on 31/7. lordship. Right side lordship, top, lordship, 31/7 we have received.
31/7. Those are computed within a period of 15 days and so. Okay. So he has caught me on my own. Mr. P.K. Roy, Learned Counsel, on instruction submit that the computation as required to be made in the matter by this court-wide order dated 27/6/2024 has already been made, and the same was communicated to the petitioner herein on wide communication dated 11/7/2024. The petitioner, in terms of the communication made, computation made is required to pay an amount of rupees 1,01,99,641. Wordzatuli Hidu. So and so. Mr. Kolda submits that the said communication dated 11/7/2024 was received by the petitioner on 31/7/2024, and accordingly, he is entitled to a period of 4 weeks from the date of receipt of such communication in terms of the directions passed by this court-wide order dated 27/6/2024. In view of the above position, the petitioner is required to pay clear the dues, clear the amount as now claimed of it by the respondents before 30/8/2024. Also, register to list this matters again on 3/9/2024.
And this matter may be fixed, my lord, on my lord 29.
Otherwise, lordship, contract is over, lordship.
That's what I'm-
There is also arbitration clause was also there.
Okay.
But my lord, we would argue, my lord, on this point, my lord.
Please,
because
please,
as-
please continue. I still have 5 minutes. This case will not take more than that. You
My
continue.
lord, my senior is on leg, my lord, Mr. NN Vishwakarma.
Then you tell that first.
On
As
29.
prayed for by the pit parties, list this matter again on,
29.
you have urgency?
No.
No urgency. Nothing. On the contract is finished.
Contract is finished.
You have gone for different set of
Oh, my lord,
tenders have been issued.
That instruction.
This is VPU.
My lord, there is an interim order, my lord.
This is VPU settlement.
Lease lordship.
My lord,
Yes,
my lease was
lordship.
terminated, my lord.
Okay, don't stay.
No,
Stays
stay, my
there,
lord,
not
stays
that-
operating.
Then,
that period is over.
Then-
I have urgency, but not that.
okay, not that. When do you want it? After
September
2026?
First week, September.
26?
No, this year only in the
You
month of
don't have
September.
urgency. What is there? List this matters again on. When do you want it? 29/8/2024.
And my lord, interim order, my lord.
Interim order passed earlier to continue till the next date of list. Arwa sir?
Timing 29. But this matter may be taken up under any other day, my lord.
Not today itself.
My lord,
You show me how.
My lord, I have to submit, my lord.
No, you don't have to submit.
But
They have
they-
submitted. You can't,
But
what will
they
you
have-
submit here?
My lord, what they have.
Appeal. You keep, that is a very good ground. This court did not hear you.
No, no.
Very good ground.
What happened, my lord, what they submitted before your lordship, we know, my lord. Lordship kindly will look the phase of this order, my lord.
Face of this order is very good,
Because,
nicely
my lord,
typed out.
Because, my lord, they themselves are violating their guidelines, my lord. As per guidelines, my lord, I am in and but violating.
As prayed for by the parties, by Mr. M. Barwi, learned counsel appearing for the petitioner to respond, to make his submissions, further submissions in the matter. List this matters again on 3/9/2024. List the matter again on 3/9/2024 for further hearing.
My instruction may be kept on.
The instructions as furnished by Mr. S. R. Barwa, learned counsel for the petition, for the respondents. Be kept on record, is kept on record and marked as X. Hmm? Mhm. Yes, Mr. Sugu. Yes, Mr. Talukdar, what is here? I have not seen it.
Hello.
Third round of litigation, my lord. First round was, my lord, due to flood, my lord, the board of directors, my lord, came before Sonamul court for extension of the term. Thereafter, my lord, flood situation was improved and they decided to hold the election, but election was cancelled. And therefore, my lord, the second round was filed before the Sonamul court. The Sonamul court directed the authority to hold the election, my lord, within 18th, on or before 18th. And
Okay, you say that the meeting was fixed on the nomination, the last date of nomination was 8/8.
8/8.
And you were not,
Paragraph
you were obstructed
17.
from submitting your
Paragraph 17.
representation. Okay, where is the FIR to that extent?
We had not filed any FIR.
What is this? You make such serious allegation.
We approached the authority immediately.
Where is that authority letter?
My lord,
Why an FIR was not lodged? Because you have been prevented from exercising your right. It's a penal action.
that should have been filed, but my lord, they approached the authority.
Fixing so and so as the date of so and so.
Clear, my lord. The authority was
Has further directed the petitions to inform them of the partitions of the said new year appointment as so and so. So and so, so and so. So sixth is not the thing. Where is that? Where is that thing? That you were objected, prevented?
Paragraph 17, my lord, case 15.
No, I want a letter. You said you have informed the authorities.
We approached the authority.
Where? Where is that document? How can we believe?
But that representation is not with them, my lord, but. approached the authority. And my lord, what happened, my lord?
You can simply issue fresh notice by tomorrow, thereby fixing the AGM on or before, immediately. You were the petitioner here in that case?
Yes.
We shall pass appropriate order. Yes, Mr. Talda, what is this happening?
But they wants to hold the election, my lord. The board, my lord, they wants to hold the election.
I know that, but Mr. Why?
That these are fact that has to be.
Now a single man will sit.
That is the apprehension. Yes.
Hmm.
That is why.
As when is the board date coming to an end? It's already come. 18th it's coming.
Today.
Today. How can we extend
On
it?
18th.
We can't extend that.
On 18 days.
We can't extend that. Mr. S.K. Talukdar,
Today is
given the
16th.
facts,
Today is
given
16th,
the,
man.
huh?
Today is 16.
16,
Yes, sir.
17, 18.
Yes.
So how can I stay this? How can I extend a board when it is not permissible under the statute? Show me how I can extend it.
Under the statute, my lord, there is no provision
Then
for extension.
still, there is no provision. There has to be an election.
Yes,
We'll resolve it. Mr. Also heard Mr. Ayat Sekel on a counsel for the petitioner. Also heard Mr. S.K. Talukdar on a counsel appearing for the cooperation department. Also, the petitioner's hearing, the board of directors of Jamadat Samavai Samiti Limited,
Jamadar Hath Samavai Samiti.
Jamadar Hath Samavai Samiti Limited, and are aggrieved by the non-holding of elections for the board members on
18. It was scheduled to be held, my lord, on 18/8.
No, there was a schedule here. Wait.
Yes, yes, schedule is done.
We'll direct, you have submitted your nominations.
No, my lord, we. the-
Submit it by tomorrow. We'll hold it election on 18th, right?
They are ready, my lord.
My lord, no, I don't have any objection.
Date of
but
nomination 18th.
88, my
Okay,
lord,
Mr.
Nominations
M-
were collected
Okay,
by 15
okay,
members.
okay, okay.
88 is
Mr.
gone.
Ayat, I heard Mr. Ayat Soikia, yeah. Mr. Ayat Soikia submits that in pursuance to directions passed by this court. The Assistant Registrar of Cooperative Societies wide order dated 7/8/2024 had scheduled the elections of the said cooperative society, the AGM oblique election of the said cooperative society on 18/8/2024. So in terms of the schedule, as spelled out in the said order dated 7/8/2024, the date of nomination was fixed, the date of receipt of nomination was fixed on 8/8/2024. And the date of election was so scheduled as on 18/8/2024. However, it is a contention of the petitioner hearing that the nominations were not allowed to be so submitted by the candidates by a section of the people, section of persons who were otherwise disqualified from participating in the selection process. Also, now, who are those people who protected you, who stopped you? Have you made them parties?
They are not participating.
In view of the above, full stop, the petitioners herein have not approached the authorities, have not brought on record any document to show that the petitioners had approached the authorities of the Corporation Department and or the police leveling, raising grievance with regard to the restriction, with regard to the
Hindrance.
with regard to the restraint as made of them from filing their respective nominations. Also, in that view of the matter, Mr. S.K. Talukdar shall receive instructions from the respondent authorities in the matter and place the same before this court on the next date of listing. Registry to list this matters again on 28/2024. We'll only have to let him have his instructions. We'll just change these dates a bit, which is there on 8.
Can it be on Monday or Tuesday?
Tuesday, 28/2024. I'm giving him 1 day's time.
My lord.
Mr. Talda, 8th, make it 20th, and then I think at a week's 15 days time is required. You can give that accordingly, and then we'll proceed with the elections. The orders of this court cannot be violated.
Yeah.
Mr. Talda shall also receive instruction as to whether any person have filed their nominations in the matter, in terms of the notice dated 7/8/2020.
Collected nomination papers.
Huh?
15 persons collected nomination papers.
Let us see. You say you were restrained, and there are others maybe who have gone. But you are the board. How can you be restrained?
So, my lord, the candidates who intended to, my lord, file
That
the
is
nomination
for the candidates to come, not for you.
my lord, the board wants to, my lord, hold the election and.
I'll just modify the order.
Elected body should.
I
run
forgot
the
that.
society.
Who are you? No candidate aggrieved has before us. How can the board have a grievance? How did you come to know that there was a restraint?
The board members were present.
Mr. Soikia, how is that a board is aggrieved? It's the members who have to come up before this court. That's it. I wanted to file a nomination. I'm debarred from
The
filing.
board wants to hold the election.
You have your instructions.
Reasonable court directed the authority to hold the election. The board wants to hold.
Will
the
this-
Can it be on Tuesday, perhaps instruction has to come from my lord South Salmora. Too short. Well, written, I have to.
22nd.
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 Yes, and the only problem is, my lord, by 18th, my lord, the section 31 may come in. What I'm trying to say, that any order may not be in conflict, my lord. Otherwise, I have nothing to
I have
say.
not stayed it.
Yes, yes,
I have not stayed it.
yes, my lord.
Knowingly, I have not stayed
Yes,
it.
correct.
Because the board, I cannot extend it.
Yes, sir.
So we will have it. That's why I wanted it on early. If possible, we will, even if a one-man committee comes in and the elections are simultaneously held, then the board will come into operation again at the shortest possible time. That is the intention of this.
They, my lord, they should be allowed, they should be allowed to participate in the election, my lord. Disqualification shall not come in, my lord, because there is, I think there is no fault on their.
That is for you. That stage we have not reached.
Yes,
That
correct,
stage will reach after 18th.
My lord.
On 20th, Mr. Saikia will make a prayer to that effect. And you also consent, this court will condone that.
My lord.
In these circumstances.
Okay. Lordship is fixing on 20, my lord, second.
21.
21.
21.
21, 8.
21 8, Vishnu.